Roll call.
Rodney Diaz, otolaryngologist and public board member.
Debbie Snow, public member, board member.
Patty Solomon Rice, speech language pathologist, board member.
Dee Parker, speech language pathologist, board chair.
Marcia Raggio, audiologist, board vice chair.
Christy Cooper, audiologist, board member.
I'm Non Shalev, hearing a dispenser, board member.
Okay, we do have a quorum. At this point in time, are there any members of the public who would like to present us with their name?
Kirsten McWilliams. Amy White, California Academy of Audiology.
Thank you.
Breanne Humphreys, Operations Manager for the board.
Paul Sanchez, Board Executive Officer.
Thank you. And at this time, we are going into open session. And I'll turn it over to our judge.
Good morning, everyone. Can you hear me okay? My name is Ed Washington. I'm an administrative law judge with the Office of Administrative Hearings. And I have been assigned to preside over our petition hearing this morning. Let's go on the record. So we have one matter this morning regarding David Michael Illich. I believe I'm pronouncing that correctly. I have had the chance to briefly talk with Mr. Illich before we got started to determine whether or not he had any questions, and hopefully I've answered them sufficiently before we get started.
Yes.
Yes?
Yes.
Okay. And just briefly to explain how the process will occur, the Deputy Attorney General will essentially present background information on your case. You'll have the opportunity then to essentially present your petition, and then you will receive questions from the Deputy Attorney General, Mr. Gatschet, correct?
Good morning, Your Honor. John Gatschet, G-A-T-S-C-H-E-T. Yes, I'll be asking some questions of Mr. Illich. Thank you.
And then the board will ask any questions that they may have, and once that process is completed, then we will move into closed session for deliberations. Understood?
Yes, sir. Yes, sir.
All right. And one thing that I generally explain during these petitions, and again, I think I talked about it briefly, is in general, these petitions are about rehabilitation. I know that you have a rather specific request, but I just want to give you an advisory so that you understand, certainly, that your packet has been reviewed. Although I received it just recently, everyone on the board has had it for some time as a Deputy Attorney General. So there isn't a need to repeat line by line necessarily everything that's in your packet. Yours is not as extensive as some others, but just I'd like you to focus on the key points in terms of your presentation. Understood?
Yes, sir.
All right. Any questions before we begin?
Yes, sir.
All right. So let's call the matter. We are on the record in the matter of the petition for modification of probation of David Michael Illich, I-L-L-I-C-H. The Office of Administrative Hearings matter number is 2018-100-612. The board number for this matter is 11-204-59. May I take the official appearance of the Deputy Attorney General assigned for this case?
Good morning, Your Honor. John Gatschet, appearing on behalf of the Deputy Attorney General's office pursuant to the government code on this matter.
Okay, thank you very much. And Mr. Illich, if you would state your appearance.
David Michael Illich.
Thank you very much. And you are representing yourself today, correct?
Yes, sir.
Okay. Do you have any witnesses you intend to call?
No, sir.
Okay. Do you have any documents that you intend to admit other than what you've already provided?
No, sir.
Okay. Thank you very much. Are you ready to begin?
Yes, sir.
Okay. The counsel, you may start when ready.
Thank you, Your Honor. I'll provide basically a brief overview of the case and then enter in the documents, and then we can turn to Mr. Illich to present anything further. What we have here is a licensee who was placed through a public approval with certain terms that would exist for the life of his license in 2004. They were related to incompetence. His license was placed in that public approval actually in 2008. He's been in full compliance for the past 10 years. There were a couple allegations of incompetence on separate occasions, a case arising out of 1998 and then a case arising out of 2004, mostly centered around improper diagnosis of very young children. He has not had that patient population now for the last 10 years, and everything appears to be in compliance. His request today is to ask that the practice monitor part of the public approval be lifted. Turning to the documents that are in the packet, this is his petition packet that's been reorganized and redacted. I've removed addresses and any sort of personal information. And then, Your Honor, I just leave that up to you. Do you want me to go through each exhibit individually and ask for admittance, or just acknowledge all of them on the record for identification and then ask at the end for admittance of everything at once?
I think the more efficient way would be to just acknowledge them on the record and ask they be admitted at once. My sense is there will be no objections, so
Yes.
that'd be my preference.
Very good. So tab 1 for members of the board is decision and order, case number 1L 2004 59. It's approximately 20 pages. Exhibit 2, ask that be marked for identification, is what's left of the decision and order from case number 1L 981106. I was not provided an accusation attached to that decision and order, but we do know that those allegations are actually contained in the accusation at page 18 of your packet, where he had previous issues of incompetence. And so that is actually documented there.
And I'm sorry, counsel, page
18 of the petition packet.
which exhibit?
I've got
That one.
date stamping both at the top,
Got it.
the right bottom, and the middle. So 18 of Exhibit 1 shows the facts and circumstances of decision and order under tab 2.
Got it.
Tab number 3, marked for identification, is his certificate of licensure, showing the 2 past public reprimands public reprimand and public approval that are on his license. Tab 4 is the notice of hearing. The proof of service is not actually attached to this. This was the copy. Actually, no, it is attached to this. I take that back. So I have the proof of service in here for him receiving notice hearing. He's obviously here today. Tab number 5 is his petition for penalty relief that he filed setting forth today's hearing. Tab number 6, marked for identification, is his narrative statement requesting the lifting of his monitoring situation. Tab 7 are the continuing education credits that he submitted as part of his petition packet. Ask that be marked for identification. Tab 8 is the live scan request that was provided to the board, and my understanding is that that came back clear. Tab 9 is the practice monitor information sheet attached to his probation, and it is dated March 5th, 2018, providing information regarding his practice monitor status and that he's had no problems according to his practice monitor. Tab 10 for identification is a letter from his practice monitor setting forth that he's complied with his probation over the last number of years. Tab 11 are letters of support, miscellaneous letters, pages 45 to 55 of support from other individuals. And then tab 12 is a probation report dated September 27, 2018, drafted by Carla Newman, just setting forth what his terms and conditions of the public approval were, and confirming that that is in effect. At this time, I'd ask to move exhibits 1 through 12 into evidence as identified.
Thank you very much. Each of the documents described by counsel have been marked for identification as exhibits 1 through 12 as described. Is there any objection to the admission of any of these documents into evidence?
No, sir.
Hearing no objection, exhibits 1 through 12 are admitted into evidence. You may continue, counsel, when ready.
Your Honor, at this time, I would actually turn it over to Mr. Ilitch. It's his petition.
I will swear him in at this time. Mr. Ilitch, please stand. Raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you provide today will be the truth, the whole truth, and nothing but the truth?
I do, yes.
Thank you. Please have a seat. And now that you are under oath, you please state and spell both your first and last name for the record.
David Ilitch.
I'm sorry, I don't think I have my microphone on, but if you could state and spell your first and last name for the record.
David Ilitch, D-A-V-I-D-I-L-L-I-C-H.
Thank you. So, Mr. Ilitch, you may proceed when ready. If you had counsel here, they would obviously present your evidence or ask questions to allow you to present your evidence and touch on the points that you think are key. What I generally tell individuals that represent themselves is just tell us what you want us to know and do it in the fashion that you think is suitable for you.
All right. I've never been defensive as far as the misdiagnosis I had on the children. I've always fessed up to it. When I was restricted with properly by the state, I immediately went back to my office and I doubled my penalty, and we put that into our practice protocol. I not only put the penalty on myself, I also put it on my fellow audiologists who work with me. I don't want to have the entire penalty taken against me as far as teaching. I don't think I should be allowed to teach. As far as supervising, I don't think I should be allowed to supervise. But the monitoring is done by Donna Maroney, who travels about 40 miles to my office and 40 miles back. Donna's getting close to retirement. Anybody who personally knows me or professionally knows me knows that myself and my practice have no interest in working with children. I've lost that right properly. So the only request I'm having today is that Donna Maroney no longer needs to come to the office quarterly to review all of our records.
Okay. Anything else you'd like to provide?
No, sir.
All right. And so, counsel, did you want to provide any background or?
I can ask some questions if that's permissible to court.
Of course.
Sir, when you were placed on this public approval, what was your understanding of how long these terms and conditions would be in place?
I was told that it would be lifetime.
I beg your pardon, I didn't hear your answer.
It was lifetime.
And do you know why that was? Or why that was explained to you that way?
I apologize. It was more than 10 years ago. I can't remember the exact verbiage that was used.
You would acknowledge that there were some problems with misdiagnosis. If you could just briefly tell us, to your best of your memory, what those cases involved.
The children that we tested had hearing loss, and our response was that their hearing was within the normal range.
And do you know why those errors occurred?
I do not.
Have you received any additional training over the years, or due to the fact that you just don't see those patients, there wasn't any additional training to be done?
Previous to the penalty, we took as many classes as possible. We took a lot of advanced classes. I honestly thought that we were more than competent from all the classes we took previous to the penalty. Since the penalty, I have stayed away from pediatrics completely.
And so, could you describe to the board what your current patient population is?
Adult and geriatric.
And you've been on now this public approval with these terms and conditions approximately 10 years, is that fair?
Yes, sir.
Any issues in the last 10 years?
No, sir.
No civil liability, no complaints regarding from patients regarding misdiagnosis?
No, sir.
And your practice, could you describe it for us?
It's a private practice. We do a lot of diagnostic audiology, and we do hearing aids.
And how many people are employed by your office?
I have 3 audiologists who work with me.
And is it your practice, or do you own it and share it with those audiologists?
I own the practice.
Any other staff aside from the licensed audiologists?
We have 3 front office people and 1 practice manager.
And the 3 audiologists that work with you, their license are unrestricted?
Yes, sir.
They don't see children either?
No. I would like to note that on this past Monday, we did hire a new audiologist, the 3rd audiologist. She has been in charge of San Diego, North County Deaf and Hard of Hearing Services. She is interested in working with children, but we've, like I said earlier, we've stipulated that it has to be 7 years old or older.
Do you feel that the practice monitor requirement has helped you with your practice?
I'm not sure to use the word has helped. It was deserved. So yeah, I think I deserved to have that monitor for the last 10 years. As far as helped, I really can't, I'm not sure to use that word in the context.
And just roughly, I mean, do you have an idea how much longer you're going to practice, do you think?
It depends upon the day. Sometimes I feel like I'm going to practice for 1 more year, and the next day I feel like I'm going to practice for 10 more years. I hurt our profession with the diagnosis, and it's something I'll never forgive. I've told many audiologists I'm a tainted audiologist because I've hurt our profession. So I love what I do. I know what my limitations are. I hope to practice for at least 5 more years.
Your Honor, that's the extent of the questions I have at this time.
Thank you very much. So now would be the time for questions from the board. What we will do is we will start to my far left with Dr. Diaz. Any questions?
Good morning, Mr. Illich. Do you perform and evaluate ABRs on adult patients?
No longer, no sir, not since the penalty.
And then do you see patients who are teenagers or who are older children, 7 to 15, 7 to 18? Do you have patients that are in the 7 to 18 range, or do you see patients that are just adults?
My practice will see children 7 years old and over. The primary 2 audiologists who have seen that population are Dr. Heather Cones and Dr. Amy Marin, the 2 audiologists I've worked with for a number of years. So my practice does see children ages 7 and older. 99% of those children are seen by the other 2 audiologists. I work primarily with the geriatric.
Okay, but in seeing those patients, you don't perform any diagnostic ABRs. All of your testing is behavioral.
Correct. Yes.
Okay. Thank you.
Good
Ms.
morning.
Good morning.
No questions at this time. Thank you.
Good morning.
Good morning.
So my understanding is that you could have brought some witnesses with you today. Is that correct?
That he was
witness-
allowed to?
Yes. So, and when I was looking through your letters of support, in our documents, in our exhibits, I noticed that all of the letters of support were from 2008, from the original case. I was just curious as to why you have not provided us with more recent letters of support, and why you made the decision not to have witnesses talk on your behalf today.
I'm glad you asked that. I asked the judge just moments ago. I had no idea what was going to happen today. I have asked 3 times, where shall I go, what shall I do? And I was very, very appreciative that Katrina on this week had sent me where to show up. Half an hour ago or so, I asked the judge He said, are you ready for this or something like that? And I said, I have no idea what's going on. So I wasn't familiar with the procedure here. I did see in the packet that I was allowed to bring a lawyer, which I did not feel was necessary. And there's really no specific reason that I did. My practice is 95% medically referred. I'm sure I could have gotten a lot of physician, otolaryngologist letters of support. I just didn't realize the need for it.
That's all my questions.
Marcia? Good one. I'm a little, it seems a little vague, what the earlier problem was with violating B&P Code 2533, in which there was a letter of public reprimand. I was wondering if you could just explain what that circumstance was, because I read about it, but not exactly what happened.
That was the child with Waardenburg syndrome, which, as we know, stands out as a real red flag. And the child had a hearing loss, mild, moderate, and the results that I got many years ago at that time looked like they were within the normal range, so it was a misdiagnosis.
Okay, so it's really not two different types of problems. I mean, the violations were the same in both cases then, and just different children?
Yes.
Okay. I'm not sure if you can answer this or not. In my years on the board, I've never seen a lifetime imposition of this sort. I'm just wondering if, I know you asked him, why did that happen, and maybe nobody knows. But I'm just curious, maybe Mr. Sanchez can tell us anything you know about it, but it just seems like an unusual punishment.
From my standpoint, I would actually agree with you. This is not something I have seen in my time. It'll be 5 years since in January that I've been with the Attorney General's office. Typically, a public reproval or a public reprimand would have a few conditions attached, but they wouldn't be conditions like a practice monitor or quarterly reports or supervision. Typically, they'd be conditions like a medical record keeping course or a single one-time course, and then it's finished. Typically, when you have these kinds of supervision requirements, you're placed on probation, and then probation has a end date. Looking at this case and backing up, he's been on basically these conditions for the last 10 years. There's obviously two competing interests with the board. One, public protection remains the highest priority. Two, rehabilitation of the licensee, and if that's possible, not to have a decision that is punitive. This decision is an interesting decision because it appears not to have a rehabilitative effect as much as a limiting effect on the licensee beyond a period of time. It may be something the board wants to actually take up today, in actually looking beyond just what his request is, which is to delete the practice monitor request, but to actually potentially take up the issue of potentially making these conditions sunset. So that is something that the board can take up today, and I was going to comment on that when it was my time to comment, but I'll just answer your question.
And if I can, so just to be clear, there are no extenuating circumstances that you're aware of that warranted is the wrong word, that resulted in the lifetime application of these terms to PLR?
Obviously, I mean, 10 years ago is a long time.
Right.
That's before my time. I will
Right.
say that this is not a normal decision that I see in my work.
Right.
In speaking with Mr. Sanchez before the hearing, this is the only decision that the board has currently where a public approval was imposed and lifetime restrictions were then placed. So I leave that to the board. I mean, his request today is
Right.
to remove the monitoring request. The board, though, has in its power to revisit this decision and can make the determination. The approval is not going away. That will remain on his license. Both approvals remain on his license going forward. If he were to have future problems, both of those previous approvals or public reprimands would be disciplinary considerations on any sort of license action that goes forward. So if he were to start treating children again, or have an issue of incompetence that comes up with his current population, geriatric population, an accusation we filed, we deal with that in the normal process, and those public approvals would be part of the discipline that the board would look at. And potentially, if he were to have a future accusation against him for further allegations of incompetence, this board might, at that point, revoke his license just on the idea here that you had incompetence issues in the past, you've now got new incompetence issues. So by potentially revisiting whether or not the board wants to keep the rest of the restrictions on his license, and understand what that means. When you keep restrictions on his license, that means that the board itself, through staff, have to continually monitor his license. He'll still be doing quarterly reports. There's also a questionable mechanism of how you would actually bring discipline under the public approval with these lifetime conditions, because he's not on probation. You can't do a petition to revoke probation. There is no, in reality, you'd have to bring an accusation, which would be the same standard of proof that you would if you had a new violation. So these are all kinds of things that could percolate today with the board when they make the decision on this case. I hope that answers your questions.
It does, thank you.
Okay.
Thank you very much for that.
And good morning, no questions.
Mr. Illich, I just want to clarify something. When was the last time that there was any complaint against you or by the monitor? When was the last time that there was any issue with your practice?
It was the last child, which I believe was tested. The complaint, I think, came in at like 2004. It was around 2003, 2004 approximately.
And
that
was there any incident in 2008 or no?
Yes, sir.
So we're talking
that's
that,
when the verdict came down.
okay, so we mean that we have about 14 years without any incident and complaint?
Yes, sir.
Thank you.
Thank you for the clarification. My major questions were related to lifetime. I had never seen that before, and you addressed those questions, so I have no further ones at this time.
Okay, any additional questions from anyone else based on questions that you've heard from the colleagues? No? Any additional information that you would like to provide based on the questions that you have been asked?
No, but thank you very much.
Okay, thank you. Anything else, counsel?
I just had a couple follow-up questions for Mr. Illich. Mr. Illich, you said that you didn't receive notice of the hearing in this case. I do have a proof of service of mailing of October 30th, 2018. If you don't mind.
I did not say that, sir.
Okay.
I said that I said that I did receive the information that did stipulate that I could have a lawyer here,
Okay.
which verifies that I did receive it. But there were other issues as to where it will be held. Katrina, is she here still?
She just had to step up.
Okay, yeah, Katrina received my email, and I had sent one to Tim Yang. I originally sent one to Carla Newman, and then I guess Carla Newman is no longer.
Okay.
So she had sent one, don't contact me, contact Tim Yang, Katrina, and so I sent a couple emails saying, where will this be, what should I do, that type of thing, and I didn't receive a response. So as of like a week ago, I sent the same email again, and this time Katrina said, she gave me the location, and what I was sending was, am I supposed to, forgive the incorrect verbiage, am I supposed to RSVP? Am I supposed to say, yes, I will be there, and where will it, to make sure where it will be held?
Okay, so you were aware of the notice of hearing, and the notice of hearing does say that you're able to present relevant evidence on in your case?
Yes, sir.
Okay, all right. I think probably some of this sounds like because Carla Newman was unavailable, that kind of threw you for a loop in terms of who to contact?
I just wanted to make sure that the board knew that I was going to be here, and it was,
I have no further questions. Thank you, Your Honor.
Thank you very much. So if there are no further questions from anyone else, then that concludes the petition hearing. The matter is closed, and we will deliberate in closed session. We are off the record.
thank y'all.
Mr. Illich?
Yeah, just stand by, Mr. Illich. He has a form he plans to provide you. Order a copy of the transcript.
Public board member.
Debbie Snow, public member, board member.
Patty Solomon Rice, speech language pathologist, board member.
Dee Parker, Speech Language Pathologist Chair.
Paul Sanchez, Executive Officer.
Kelsey Pruden with the Department of Consumer Affairs Legal Affairs.
Marcia Raggio, audiologist, board member.
Christy Cooper, audiologist, board member.
Amnon Shalev, Hearing a Dispenser Board Member.
We have a quorum. Are there any members of the audience who would like to introduce themselves at this time?
Vanessa Kahina on behalf of hearing healthcare providers.
Bill Bartlett on behalf of hearing healthcare providers.
Amy White, California Academy of Audiology.
Brianna Miller, TCA Board of Bureau Services.
Caitlin Jones, the California Speech Language Hearing Association.
Brianne, I am the board operations manager.
Thank you. At this time, I would like to call Christy Helen Cooper up so we can give her the oath of office.
So the meetings until now were not legal.
My phone's in your car.
You're legal. I don't want to miss a word, and somebody will take a picture for you, okay?
Oh, good. We got
All right,
two.
we'll take a picture first. Oh, you want to hold
Two
your
vantage points.
Okay. Okay.
All right, let me get back.
I had a better idea than I did.
Okay, all right. I, Christy Helen Cooper,
I, Christy Helen Cooper,
do affirm that I will support and defend
do affirm that I will support and defend
the Constitution of the United States
the Constitution of the United States
and the Constitution of the State of California
and the Constitution of the State of California
against all enemies, foreign and domestic,
against all enemies, foreign and domestic,
that I will bear true faith and allegiance
that I will bear true faith and allegiance
to the Constitution of the United States
to the Constitution of the United States
and the Constitution of the State of California,
and the Constitution of the State of California,
that I take this obligation freely
that I take this obligation freely
without any mental reservation
without any mental reservation
or purpose of evasion,
or purpose of evasion,
and that I will faithfully
and that I will faithfully
and well discharge
and well discharge
the duties upon which I am about to enter.
the duties upon which I am about to enter.
Congratulations. Okay, and I think that goes back.
There you go. Thanks, Paul. Thank you.
Congratulations.
Just over 10 and 8.
They don't say anymore, so help me God. No?
Should we go?
So help me God. Does that help?
Don't make you raise your right hand.
To where?
I didn't have to. I thought I was supposed to.
It makes, it's invalid if you don't raise your
Here,
hand.
zero.
It could be 5 feet.
I can't do that.
Okay, 5 feet.
We're back there.
We're
Don't say too many
going
words.
back to 5B, and this is the discussion on supervision of trainee applicants, supervision and training required, and direct supervision.
There was a list.
So where we left off is we were on the topic of indirect supervision, or those tasks that would not be considered immediate or direct. I didn't receive anything specific from anyone on what indirect would be, but I think we were at a point where we felt like we needed to continue the conversation for today. I think for simplicity, we'll probably work off of Kelsey's color document, and we may have to refer to the other two, but I'll keep watch of those other two versions to look for changes or anything that we might need to focus on. Does that make sense?
Yep.
Okay.
And since we don't need to use the blue anymore,
Oh,
the blue highlighting.
Right. That mysterious shade of blue.
Should look different on my computer, I promise.
So we're
So
doing
just-
version
just-
two?
Give us one version.
Version two is what we're doing?
I wasn't. This is sort of one version.
I thought there was some idea of condensing it down.
We were
so
going to,
didn't have
but
a bunch of different
we were going to, but we only had really 2 changes to make, so we thought we would just work off of this one.
Okay.
And I want to make sure that we covered everything in the beginning of the document, and we went over the changes in the beginning, right?
We have not settled on the CE.
Okay.
There was a discussion on it, but I don't think there was any motion or consensus as to the continuing education portion of it.
Can I just clarify, are we working off of version 1, 2, or 3? Which
3.
ver- 3, gotcha, thanks.
That's this one.
The color,
The colored one.
The color.
the one that's
okay.
printed in color.
Got it.
Where, this one, that,
Yes,
okay. And which page of this one?
it's the first page, and it's subsection C, which is underlined and has
Yeah.
a comment.
Yeah, I have a question to this. Is this continuing education on this development supervision, is it readily available in the market? Are we familiar who is providing kind of thing like this? I don't want to have a request that cannot be fulfilled. If anybody knows about, are you familiar with any?
I'm unaware of anything that specifically would fit California's criteria. International Hearing Society has more of a federal, but they do cover things that may not be listed in our scope in their training.
So I
You
think
don't
what-
want it to impede being a supervisor just because you cannot reach a training like this. That's all.
Right, but as we've talked about yesterday in other professions, and I realize hearing aid dispensing is a separate profession from audiology and speech language pathology, but once you create a regulation that requires some type of continuing education, people will start teaching them. So maybe it won't happen in month 1, but within 6 months or so, people will be teaching them.
But there's so very few incidents like this in the state. I don't think it will make somebody a teacher for this. It's only a few people. It's not like.
My guess would be there'll be some online classes that will be created that make it very convenient for people to take the courses.
I think to make a regulation on the hope that the market will create this training is really a little bit far-fetched.
It happens in speech language pathology and audiology all the time. So
Well, we have, I think, how many, we have like 1,800 dispensers here in the state and 25,000 speech pathology. It's a different market. I mean, could be in speech that you have a market for this, but.
Well, audiology has its own also, has its own CEU for supervision coursework that we had to develop.
You have some, so it's available?
Absolutely.
Oh, okay, so if there's something like this, that's fine.
Dispensing audiologists have the same requirements of taking supervision coursework.
So Marcia, the supervision courses available to audiologists, are those focused more on supervising RPEs, or are they focused on supervising hearing aid dispenser trainees? Okay, so that, just to be clear, they're not for hearing aid dispensing, they're not for trainees of hearing aid dispensing, what Marcia is referring to.
Yeah.
Another point of clarification is that there are only, at any given time, 200 trainees. So the most supervisors we could be talking about in any given year is about 200 people. So I also raise a concern, I'm not opposed to requiring this, but I did raise a concern that I know I'm going to hear about when we try to actually put this rulemaking file forward, and that is on the limited classes that are currently available, or if any are available.
If I may add, that is if each is 1-to-1, but you can currently have up to
Right.
3, so that could be even less trainers as well too.
Right, that's why I said the most possible. Some of those supervisors are audiologists too.
But need is the mother of invention.
Yes.
That's true.
Yeah.
That's how you.
Mhm.
To piggyback piggyback off this conversation, what I just noticed also is there's no requirements for length of licensure prior to supervising an intern. That I know we have, the board has included for other professions. And I was actually just looking at Florida, and they have to have been licensed and actively practicing for at least 2 consecutive years immediately prior to it. They have some sort of certification by NBCHIS.
I believe that's the same in California. I've always been under the direct impression that it is listed as 2 years before you can
Okay,
train
so
somebody,
maybe I'm just not looking at the right thing.
Yes,
Yeah.
it's 3 years.
I believe it is.
Oh, no, you're right. Wait. It says supervising dispenser shall have possessed a valid license as a hearing aid dispenser and engage in the practice of fitting, selling hearing aids for at least 3 years.
Oh, okay. I apologize. I wasn't looking at the right place.
Okay. Questions too.
We, that is in the audiology community, piggyback those courses into the annual conference. So it is convenient, people are already there, it's just one more course. So it could be done that way to make it a little more
I
convenient.
kind of refrain from kind of pushing forward. I mean, if the regulation's in our hands, we have to deal with it. I just know that it's more of an obstacle than what we've been. It's not where we've been coming from in this sort of thing of being an active license that is nothing against you when it comes to the board. You've been doing it for 3 years. That's been the stance that we've gone through a long time. I know that changing the supervision levels is, I think, a great change. I think that adding this is actually a detrimental type of a change, so I wholeheartedly agree or disagree with it. I believe that it does create a barrier. I believe that, and I don't think that as much as we get hypothetical, there's a little bit better to deal with in non-hypothetical with that as well, too, to be honest with you. We have a very good current stance of saying that you've licensed for 3 years, coming out of a high school diploma, you've been licensed for 3 years in a profession actively. You have no dings against you on your record. Now you can teach vocationally to someone else. That's the current way that it exists. And now you're adding further courses and classes on that same sort of thing. I feel that it's going to create more of a barrier.
Actually, it shouldn't be that way.
I agree that it shouldn't, but it could.
If we look at the coursework for audiology and speech pathology as examples, there are supervision courses that are specified for supervision only because there are so many aspects to not just adequate, but the supervision in general, that they've carved out coursework just to teach professionals how to supervise. Because just being a professional doesn't make you a good teacher or supervisor. Just because you fit a hearing aid doesn't mean you're good at teaching somebody how to do it. So that's why they've carved out these extra courses within our professions to make better supervisors.
But can the board provide right now, if this statute was in law right now, can the board provide to dispenser a couple of names of training that he should go there? Or they don't exist today? If they don't exist today, it's a problem.
So
Well, if there's never been a need for it, then why would there be any pre-existing?
But it will take time, and I don't know if it will have somebody to train this. And what will happen right now, if we implement this language, right now, there's no supervision anymore there's no supervision anymore right now, immediately, until somebody will come with the training.
So first of all, regulations take 2 or 3 years to become effective, so there is certainly time to develop this coursework.
No, but nobody's gonna develop it on the promise that there will be a regulation.
Well, it goes through the regulatory process, so it's very clear that it's going to be a regulation. It just takes time to move through the regulatory process.
I think it's a risk that nobody will be able to supervise somebody, and you're gonna stop the whole program until a school will be, and it has to be approved probably by the board. The training has to be approved by the board. It's also a process.
That's true for audiology and speech language pathology as well.
Yeah?
One correction I would say, I believe you're saying 3 years as to what's listed here, or are you looking at something different that you're reading?
No,
3
I'm
years?
actually looking
I
at
believe
the-
that's a change to
I'm
3
looking at the
years.
regulation. The
Okay.
regulation currently in 1399.116 says that here, a licensed hearing aid dispenser shall not supervise more than one trainee applicant at any one time unless a specific waiver has been granted by the board. Criteria for the waiver, oh, you know what, you're right. This
Yeah,
is,
this
this
is the
has to do with
change
the
you're
waiver.
asking to change,
That always
yeah.
throws me
Okay,
too.
because
Yeah.
2 years is current, and you were asking in this to
Right.
change to 3 years before,
That's reading
have,
the waiver.
before being a trainer. I believe that's the, so that would be another change, which we're not in opposition to that. I think the better on-job training, I think that's fine.
Are you looking at A1?
Yes.
Is that
Yep.
A1?
I'm looking at the it's listed throughout A of 3 years here, 3 years there on the current page, and I believe in the, if you look in the actual, this I believe is a change to 3 years that's on this page, because I've trained numerous people and I.
What change are you referring to, Joe? I don't see a change.
I did that, okay.
It's 3 years, right?
I apologize, I'm under the full impression it was 2 years, and I will retract my portion of that, so, yeah.
Are you referring to
3 years.
the
3
section I
years.
was just reading?
Yes.
Okay, I just want to be really clear. I think, Kelsey, you were right the first time.
Yeah.
Wait, can you say that again?
I apologize.
I think our
I'll look back
legal
at my
counsel was
references
correct
and
the
see,
first time she spoke.
It appears everything in.
I incorrectly
shows
corrected
that I was
her.
incorrect, so.
So let me just be clear. The 3-year requirement is for a waiver. A waiver is an exception to having more than one trainee at a time. It says the criteria for a waiver shall be, you have to meet all these conditions, and one condition is you have to have been a supervisor for at least or a licensed dispenser for 3 years.
So for one person to supervise, you don't need any?
You don't have a time requirement.
You
Oh,
could have
we
been-
need to put, even
Yeah.
for the first time,
Yeah.
we need to put something.
So what do you think is an adequate amount of time?
I think 3 years, 3 years is fine,
Actively practicing for 3 years?
yeah, without any
Do we
violation.
want to
of
say
it.
actively practicing for 3 years since the date of
They got the license.
becoming licensed?
Or no,
Well-
the
Or that.
proceeding of the
Or
supervision.
the
Proceeding,
temporary.
or maybe consecutively, so you would want it,
Yeah,
maybe they practiced for a little bit and then took a break and,
no, 3
Okay.
years prior to
okay, 3 years prior
the supervision.
to the commencement of supervision.
But 3 years what? 3 years of being licensed, 3 years?
No, of practicing.
Active licensure and practicing.
Okay.
Is it active California licensure?
Yeah.
Okay.
There's another statement in those,
Yeah.
in the regulations that I'd just like to point out that I've had a difficult time with, because in the very beginning of that section 1399.116, we say a licensed hearing aid dispenser shall not supervise more than one training applicant at any time, unless a waiver is granted. Then we lay out a criteria. And then if you go to B of that same section, it says, a licensed hearing aid dispenser shall not in any circumstance supervise more than 3 training applicants at any one time.
Yeah.
So we're stating that they cannot, except for under certain circumstances, and then we're stating that they cannot under any circumstances. So it's interesting language.
Yeah, I mean.
So basically, the waiver is for 2.
Right.
Yeah. But yeah, I don't, that language should probably be changed.
I never thought that way, but now that you bring it up, yes. It's kind of a puzzle.
Okay, so if the board is still agreeable to those terms, I can
I-
work on massaging that
From all,
language.
from 116, I still don't agree to C.
Okay, well, we're not quite there yet. But, so I want to make sure that because I'm adding to this.
Yeah.
So first we have that we need to add a requirement that before supervising, the supervisor must have had an active California license practicing for 3 years prior to the commencement and no discipline during that time.
Yeah.
And then, is the board still okay with the waiver for 2, but not 3, but changing that word verbiage so it's not so confusing?
Well, the language you can change as needed, but I think we agree that up to 3 people.
Well, I think that's what we're asking, because of the
Should
way
it be? Yeah.
the way the language is written, it doesn't actually state that. It actually says under no circumstances.
More
Yeah.
than 3.
So
it's
what's
2 to
wrong?
3, yeah.
So I just think it probably needs to be reworded to.
Yeah, but we all
that's
understand
confusing.
it's up to
Okay.
3
Yeah.
people.
So how would you reword
You
it?
cannot go by any,
I would
4
probably
people.
merge A and B together
Yeah,
so that it's just in one place
There
and
you go.
very clear.
yeah.
So do we get lots of requests for waivers to supervise up to 3?
Let me talk a little bit about that. That's
Yes.
that's a good time to talk about this. The other thing we need to know is what the desire of the board is as far as the number of trainees a dispenser can supervise. Because part of the problem, Amnon, that you were originally
Yeah.
trying to address were the trainees that were just left alone. And
Yeah.
this regulation lent itself to that, because on one hand, we're saying you shouldn't supervise more than 1 trainee.
Yeah.
Except for under certain circumstances, you can supervise up to 3, and you only have to supervise them 20% of the time. So, do we feel comfortable with the changes that we're making, that we still have the same requirement? The requirement is you shall supervise no more than 1 unless the board is willing to waive it or make an exception.
Well, the reason you're asking is that if somebody supervises 3 people, how can he supervise them?
Exactly.
And you are taking the assumption that each one of them is in different branch.
No, I'm not making that assumption. I
No,
was
but
referring to what
if somebody decide to have 3 trainees in the same office,
Right.
he can supervise them if they are all in the same location. If he
And
wants-
that's what I'm asking. Actually, I'm not making that
Yeah.
assumption. That's something that I think
Yeah.
you brought up a few meetings ago,
Yeah.
that there were these people that were at separate locations.
Right.
So I wanted to make sure that we are comfortable with the regulation requirements as far as the number of trainees, the way they are with the changes that we're making, or if we need to address this too.
I don't think there's a problem with,
Okay.
with 3 people, or maximum of 3 people.
So what I will point out though is now that we've added the requirement that the supervisor meet the same requirements of the waiver really does
That-
not
right.
have.
I don't think we need a waiver.
So no waiver, so should it be that it's just you can supervise
It's up to 3. Yes.
No more than 3 under any circumstance?
Yeah.
Waiver.
And one thing that's good about that, just because I harp on consistency a lot, is that's the same requirement for SLPA supervision as well, that SLPs can supervise a maximum of 3 SLPAs and/or aids in combination.
Now, we can talk about C.
See, I said until we have training, if we implement this first, there will be a time that there will not be able to supervise trainees because of lack of training courses. And this can be something that will feedback itself. I mean, there will be a time that there will be no trainees because the lack of C educators, and because there is no CE educators become available. You see what I mean?
So
There will be.
one thing we can do about that, whatever number of
Yeah.
hours we decide to do, is perhaps as a board, we can request that someone develop that continuing
How
education.
can we request somebody to do a business?
Ask our hearing aid dispensers,
What?
put out an email and request that they develop a course that we can place, I don't know if we can do this, but if they're one of our providers, place it online with a link. I mean, can we do something like that, or is that marketing, or I don't know.
I'd have to look into it more because you do have to pay a fee to become a CE provider approved by the board. So
Yeah.
we'd be advertising for that. So I'd have to look into, I don't know off the top of my head.
Or perhaps your
if that's
association could develop that
Right.
type of
My
course.
immediate feeling is it's not currently covered under what our CE scope and our training would be. We've been very limited lately as well. So to add that we can gain a CE for training supervisors where that's not necessarily a scope practice thing.
Although it will be going through the regulatory process to become it. Anyway, it's just, those are some things that our associations do, that speech language pathology and audiology does. So as an example, in speech language pathology, not at the licensing level, but at the national level, there is a new standard coming on board in 2020 that you need to complete 1 hour of supervision and continuing education, and they are offering that through the National Association, free of charge for people. That's how they're implementing it. It's also a way to get new members.
I know I think we're fighting the chicken and the egg at the same time. That's
Well,
what
and-
it feels like to me.
So-
What if there will be one provider, and then after a year it decided to go out of business? Then we stop the whole training program because now we don't have it. It's a limitation that's hard to overcome.
May I speak to that? So, having put on the California Academy, Amy White, CAA, having been very involved in our conference for a number of years for the California Academy of Audiology, and having presentations on this supervisor coursework, I think we'll find, what I have found with us offering that at conference, it actually lends more people to getting interested in becoming supervisors and feeling better prepared to do so, so they're more willing to take on students or people interested in the field. So I actually think you'll find that it does actually grow your practice numbers rather than limit it, because you'll have more people feeling like they understand what being a supervisor means. In addition to that, most of the people that we have present oftentimes are people that present nationally on these topics and can do that for audiology as well as they can for hearing aid dispensers or speech pathology, because a lot of what they present on isn't necessarily practice specific. It's more how to manage people, how to interact with people, personalities, and so on. So there are a number of people on a national level already doing that. So I don't think, we have to come up with some whole new program. And I would like to very much thank all of you for putting in the time. I have so many students that go get their bachelor's degrees and then don't go on to the audiology program that want to become dispensers. I have a lot of them that I observe with me all the time at work. And I feel like a common complaint or a point of confusion is a lack of structure on how to achieve becoming a dispenser. And I think actually the development of more AUD programs in the state is actually going to lead to a lot more people trying to enter the field of dispensing who decide not to go on and get their AUD even though they got their bachelor's. And having more structure I think is a good thing. And I think it will help get more people into the field, which I think is necessary as well.
Yeah, but I'm talking of even our point of legality. I don't believe that we can legally put a regulation on something that's not available.
Well, one thing we can do is we can put a future implementation date to give providers an opportunity to develop a supervision course.
Yeah, but we have no control.
Well, I think, while I understand that, I actually brought up this issue, so I'm bringing it up because I'm already anticipating, when you do a rulemaking file, you do an economic and a fiscal impact, and you have to weigh all those issues. But at the same time, if this is a necessity, and if it would, you know, on one hand, I understand the argument of it being a barrier, because someone might say, well, I don't have time to go take more courses, so I can't be a supervisor.
It's not the time, no. Of course, 4 hours is not the time.
Or they might say, it's hard to find a course that I could attend, or.
It's not existing now, right now.
The other barrier would be that if I don't know how to train people, or that they're not gonna pass the exam. So if we actually have better equipped trainers, then they're more likely to pass the practical and the written exam.
Yeah, look.
If I can just interject for a second, I know that there has been some topics recently that has been stated with audiology, and that you're describing, their CEU availability and what they can take for their courses to get CEUs is more broad, where the dispensing CEUs are much more scope of practice based. In fact, there's been denials for tinnitus CEs because we can't get CEs on courses on tinnitus. So we're adding courses on infrastructure of training people that has nothing to do with scope practice of fitting and selling hearing aids. So now if we're broadening the scope of a dispenser to be able to get CEs for training people, it doesn't make as much sense. I believe it creates a little bit of I think some hypocrisy in the actual wording of how that all works there.
Well, the other professions have such requirements in place already, and they didn't have them prior to the regulation. So they had to develop it, and that's what this profession would have to do. And I assume some of the impetus here has to do with the failure rate for the written and practical exams, as well as perhaps other advertising violations or other kinds of violations that hearing aid dispensers experience. That's the impetus for this, is to improve the quality of the individual who ultimately.
Well, and the other issue that we really have to, an argument for more of this type of training is that we are actually allowing someone who has no background potentially or training to come and work under the supervision of a hearing aid dispenser. So we're allowing that to happen. And I think that's why we're really doing this, because we want to have some structure and make sure that the supervisor is just getting a certain amount of training. I think that's what our reason for doing this.
We started with the whole issue because we thought it's not safe to have somebody doing ear mold impression without any training unsupervised in another city. And look, we are drifting into killing the whole program by this. And by the way, I believe that if a dispenser will file a suit against the state by putting this regulation, I think it will prevail. If the state, what will be the defense of the state? Hey, you have to do, you have to find out.
Quality control? Is that
Protecting the consumer.
Consumer protection? Is
Pretty
that,
much.
What?
indefensible?
No, but if I want to be a supervisor and the regulation calls for something that cannot be implemented.
That's just a false premise right there.
Why?
Because you have to develop things when a requirement like this comes along.
Yeah.
It is in the onus of the profession to develop it.
But there's no one, there's every
you can't say that.
dispenser is individual.
You can't say that.
Every
There's
dispenser
no
is
one.
individual. What, the dispenser as individual will develop a program?
No, that's a false argument also.
So?
The onus is on the professional organization to start putting the word out there that this is coming down the pike, and it will evolve, because it has to. And that's how all the other professions did it too. They didn't start with one, they didn't have it, but they developed it because the regulation was there that they had to. So they did. And that's what you would do also.
I have a question. If this CEU training can be approved as a CEU for dispenser, as part of that, you know what I mean? There's a list of CEU that's providing out of the 12 hours that we need. Can we include this in the CEU? So this will be one of the subjects that everybody will do.
That is what we're intending.
No, is this right now, I'm asking, will be approved by
I would argue it's
the,
out of our scope of practice.
Huh?
I would argue it's out of the scope of practice.
What
And
is?
What to
Be training, doing a course in training on hearing aid dispensing would be, or training to be a supervisor. You're talking about kind of a global thing. I would say that's out of the scope of practice of what a hearing aid dispenser should be.
Can dispensers be supervisors?
They could be supervisors, but earning a CE is what I'm talking about. You can take courses in supervision, but earning a CE for courses in supervision, I believe is out of the scope of
That
practice.
makes no sense to me. If you can be a supervisor and it's mandated in regulation
That is
that you have to
supervised.
be a supervisor, then having additional education to
yeah.
support that doesn't seem out of the scope.
I think if the board will approve that the 4-hour CEU will be part of the 12 hours, I think dispenser will take it. And if the board approve it as a CEU, one more subject to learn.
So I did ask yesterday whether or not that was as a part of the 12 units of the CE, and the board did seem to say that it would be a part of those
Yeah.
12 units
If
that
it's a part
are
of the 12,
required,
if it's
not
a
in
part of the
addition to.
12, I think everybody, I'll take it, you know, I mean, everybody will.
And again,
If it's a part, if the board will approve these 4 CEUs as part of the 12, then it's a benefit.
that was the intent. And then also, sorry, I just wanted to point out that it is highlighted because 4 is a number that Heather and I came up with. It's been 6, it's been 4. The CEs are different for hearing aid dispensers than they are for the other professions, so it's hard to compare again here. But that is a number that the board will need to decide on.
But Anna, it's always been the intent that the supervision hours are a piece of the total number of continuing education hours. It's
Well-
never been the intent to be separate from or in addition to.
Was that HHP's understanding that this 4 was going to be part of the annual 12?
It was unclear to us.
Okay,
Okay,
so,
well then, okay, then.
that's, I'm glad you're clarifying that.
Yeah.
It is part of the overall 12. And I just want to state that I do get a lot of feedback from hearing aid dispensers that these courses, that just a regular CE sometimes, that it's difficult to find courses. I get feedback from audiologists that the dispensing courses are difficult to attain. So I did want to throw out there, if we're going to do something like this, we can put a future implementation date on the regulation, if that will help alleviate that at all, or give someone an opportunity to develop these courses.
Yeah, I believe if it's part, it will give an incentive, because you go in a convention, you have speakers there, and you will be, some speaker give supervision, and it might help.
Do we have have we settled on a number of hours?
So, how about if we get reminded of what the hours are for the other 2 professions right now? So, and what the regulations are for the other 2 professions, just so that we can have a basis for comparison.
Okay, so right now for hearing aid dispenser, I will say it's 12.
Every 2 years?
No,
Every
annual. They are
Annual.
annual.
Okay.
It's the same across the board now. It's for dispensers, dispensing audiologists, and audiologists and speech language pathologists, where it's 24 every 2 years for a speech language pathologist and audiologist, and for a dispenser and a dispensing audiologist, it's 12 years every year.
12 years.
12
every
years.
Not 12.
12 years. You have to have 12 years of CE every year.
If it also, if
I've been reading these rates.
Marsha,
So,
if it's
actually, that's
same
not what I was asking. What I was
dispensing
asking is
audiology
the
has to do the same thing, right?
So what I was asking
As
is the number of
supervision.
supervision
Learning someone
training,
to
not
be
the
a
total
dispenser,
CE.
right?
Audiologist? We do.
Will,
I'm
this
just-
regulation will be also applicable to dispensing audiologists, right? Who wants to train
Yeah.
a hearing aid dispenser?
Yes.
Yeah.
Now, one thing that could be considered is looking at the RPE supervisory. It does ask for more hours
Yeah.
and more continuing professional development, but it allows it to be not every year, but every 4 years. So would it be
Not-
reasonable to ask for this?
Oh,
this
of course,
continuing
not
step
every, I
less-
don't think
less
that you have
often?
every year,
Oh, yeah,
not
that's
every
way
year,
too
not
much.
every year.
Yeah.
It's, I think according what it's written here, it's one, right?
Yeah.
I could tell you what the requirement is for
What,
RPEs.
right now, it's once in a lifetime, no?
Oh, right now there is no requirement. Currently,
Or one time you go to the CE and you can be a supervisor. If you pass the 4 hours,
that's not how it's currently written, no.
how it's written?
It's 4
It's 4
hours of continuing, wait, hold on.
in
It's
professional-
4 hours prior to being a supervisor,
And
and
then
then
two-
2 every year thereafter. And so maybe,
I
maybe
don't
changing
know,
every
I don't,
so much,
I don't
yeah,
think we
that's
need
way
the
too
2 years ever after. Once you have been done it,
Right, and that's much more than speech language pathology and audiology, so we need to, though, just confirm what it is for speech language pathology
So,
and audiology.
so are we talking about RPE supervisors
We're talking about,
or SLPA supervisors?
I think we should talk about SLPA supervisors.
Okay, we just actually
we just changed it.
changed it.
I'll look it up.
so,
I can tell you, while she's looking that up, required professional experience supervisor must have completed not less than 6 hours of continuing professional development and supervision training prior to assuming the responsibility as supervisor, and 3 years of CPD and supervision training every 4 years thereafter.
3 hours every 4 hours.
So 6 prior to and 3 hours every 4 years.
But but let's check the SLPA ones, because that's more, those are more similar.
I
Where's the
think
SLPA
also
section?
that there should be a person who go for the 4 hours will maintain the records of this. If he's supervisor 5 years later, he can show that he has to maintain the record. Because I think that right now the requirement to keep record of continuing education is 1 year or something, or I don't know,
I think
by the
it's
board.
2.
Huh? How many years do you have to keep? 1 or 2 years?
AIDS and
The record of continuing education.
Audiology is AIDS, but SLPA
The
is
person that
assistance.
done continuing education, how long does he have to
They
keep
just
the
have to
records?
register.
2 years, 2 years, okay? I think supervision should be longer than this if we're doing it a one-time training.
3 years?
No, we should, the person should keep it like I got a license 30 years ago, I keep it, right? So you got a CEU on supervision of, you keep it in your record forever.
Yeah, not that you wouldn't. I
Yeah.
thought we just, but it's the
The
continuing,
continuing piece.
the continuing education for that, that's in C, the last sentence in C.
You're talking about the 2 hours? No.
Yeah, 2 hours
I
of
think-
CPD every year
Oh, no.
thereafter.
It's too
So-
much.
Every 3 years?
So for the SLPA, they have to complete not less than 6 hours of continuing professional development and supervision training prior to the commencement of supervision, and 3 hours in supervision training of continuing professional development every 4 years thereafter.
The same.
Okay,
Okay.
And it used to be 2, and we changed it, the board changed it to 4.
okay.
That
Great,
seems
thank
right
you.
then. Where's that?
So it used to be 2, and that is in 1399170.15, subsection E. But your book will say 2. The board recently approved the amendment to 4, but it has not become a regulation yet.
So how do we feel now about the requirement, the four and,
I think 4, I don't think that need any other every few years. But also, I think that should give some, can we put some time allowance to start the program of only for C, like a couple of years to.
Future implementation
Yes, future
date?
implementation of C.
Okay, so let's do some quick math here. If the board were to approve this language today, it would probably, in all likelihood, take a year for the regulation to come into effect, and that
Yeah.
is being generous.
Okay.
So that puts us into end of 2019.
Yeah. So 2021, we'll start C.
2021.
C.
No later than January 1st of 2021.
I think
December
you mean no
3rd,
earlier.
December 31st.
I think you mean no
No,
earlier.
that's too far away. Ain't rocket science.
And then as far as the continuing education after the initial 4 hours, we have 2 years of continuing professional development and supervision every year thereafter.
No.
Seems like it should be 2 hours of continuing professional development and supervision every 3 years
I
thereafter.
thought we said 4 years because
Or
then it
okay,
matches
4
the
years is
SLPA.
fine. 4 years, well,
Isn't that what you read?
Yes.
yeah, but they have more, they have 3 hours every 4 years, so, well, that's all right, we can say 2 hours every 4 years, that's fine.
Okay, so in terms of an implementation date, 1 year after the effective date of regulations,
2 years.
Should be more than adequate.
Yeah, so.
So they have a year
2021.
and then they have 2 years to get this together. That seems, we're talking about putting together a course, you know, it's not
4 hours.
hugely difficult.
And this can be online also as well, right? Okay.
Yeah.
okay, so I'm hearing 1 year from effective date of regulation. Or some sort of calculation of that.
And then it applies to those people that were renewed. No, never mind, ignore that. Just one other question. I'm thinking of regular CE audits, and I don't wanna confuse everything here. But the way we wrote it was that the initial 4 years has to be completed in a 2-year period prior to the commencement of supervision. And I think the other regulations don't state that, do they? Are they that
RPE
specific?
does.
Oh, is it? Okay.
Let me, sorry.
That's not SLPA though.
I think they probably do the same.
So actually, the latest so the regulation actually says in the initial 2-year period prior to the commencement, and that was removed. The board removed that language and just made it prior to supervision.
Okay.
So for consistency, does the board want to remove that prior in the 2-year period?
Yeah.
Did we do that because we thought people did that recently? They didn't do it 20 years ago?
I don't recall.
But they didn't exist, so they couldn't have done it 20 years ago.
That's true.
We probably did it to make it consistent with the other requirements, I imagine. I don't know either.
I should just keep this little stuff out. Okay, so quick recap. Gonna add the 3 years active California licensure requirement prior to the commencement, removing the waiver, no need to have a waiver, maximum of 3. Rewording subsection, or actually, I don't need to reword subsection, to be, or just be, sorry, because it's just gonna say now that they can't do more than 3. And then in subsection C, there's going to be, removing in the 2-year period, removing every year thereafter to every 4 years thereafter. We're gonna add language to make it abundantly clear that it is a part of their 12 CE units, not in addition to. And then also add an implementation date of 1 year from the effective date of the regulations. This comes into play.
Yeah, so, and do we have to put or not that that it can be an online training? It's important because I believe it has to be, because nobody is gonna wait to be, somebody wants to train someone, oh, we'll wait to May, there's a convention and there's a training there, I'll be able to do it in 8 months. So it has to be, okay, I want to train you, I have to go to the online, finish this, now I can train you. We don't want to wait 8 months for the convention to go start training. So it has, so we have, do we have to put in language that this training can be done also by online
I think
training?
the way it's written, it would be allowed as online training. The overall requirement for hearing aid dispenser is limited though. So out of the 12, 6 can be, well.
Yeah, this can be part of the
Right.
of the 6. No, but
So there's no specific restriction on this.
no,
requirement.
yeah, because somebody can take the 12 and now he wants to supervise. He will really have 16 hours. That's not a violation to have more.
Right.
But it will have to be that the board will recognize an online training for this purpose.
It's already in the CE stuff, if I
Yeah,
remember correctly,
yeah.
that CEs are allowed online to a certain extent.
Yeah.
Yeah.
So I believe if it's a CE course, that would be.
Okay.
That's my own.
Okay. Does the board want to vote on this particular section, or do we want to just move on and do it as a
Yeah.
whole?
Yeah.
We can vote on this one and kill one at a time.
Whatever.
Right,
Yeah, okay. So I move to approve section 1399.116 with the notes of council.
And for the formal rulemaking, and to delegate to the executive officer to make any technical or non-substantive changes. Is that included
Yes.
in that? Okay. Is there a second?
Second.
Is there any further discussion from members of the board? Okay. Moved and seconded, Ron?
Oh, public comment.
Oh, public comment, yes. Okay. Hearing none, Rod?
Yes.
Yes?
Yes.
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 Motion passes.
If I could just clarify before we go to the next section, there are no restrictions on online training. The restriction is self-study. So I want to be clear that when I said the restriction is that only half of your C can be through self-study. If you go online and do like some type of online interactive training, that's just considered normal CE. Okay, thank you.
Okay, so moving on to 1399.118. In subsection C, at the last board meeting, the board listed out various different tasks that had to be trained, and added, at least for the following, for the duration of the trainee applicant's temporary license. And the changes made here were, sort of technical in nature, spelling it out. But HHP's letter pointed out that in number 10, knowledge of verification techniques for hearing aid fitting, including real ear measurements, that it was possibly vague, and I think they also requested, if I'm remembering correctly, that it just stop at knowledge of verification techniques for hearing aid and fitting, or was that a different one?
No, that's correct.
Okay.
And I think it's very similar to the way that it's written currently.
I have a question. Real ear measurements are not part of the testing for getting a licensee, right? So why should it be here, part of it? It's not part of the scope of.
Is it?
Well, I guess the question should be, should it be?
Yeah,
If
I
it
don't
should
think
be-
if
if
it's
it
not
should
part
be,
of
we
the
should-
scope, if it's not part of the scope of a hearing aid dispenser right now, so
well-
why should it be?
So
Right.
rather than assuming it's not on the exam or it is on the exam, I guess the question we should be asking is it part of the scope of practice? And if it is this something that needs to be trained? And then we can look at the exam and make sure that the exam covers it.
It's on voluntary purposes. Some people like to do it. There's nobody prohibited on a hearing aid dispenser to do real ear measurements, but it's not a mandatory.
This doesn't sound like it either. It says knowledge of. And I don't know that means it's mandatory that you do it.
Well, so
That
here
doesn't-
is the problem, is that it's a little unclear because
Yeah.
it does say that the supervisor shall train in at least these things. So you have to train in that. So
Yeah, I mean,
is it clear what that is?
They're trained in the knowledge of rather than trained in the practice of. So I think it's essential that they know about it and know that is there. Not everybody's going to do it, but
of course,
it doesn't hurt to know about it.
a lot of offices doesn't have real ear measurement equipment.
But that doesn't mean they can't know about it and talk
Yeah,
about it
you
and
can-
inform their trainees about it.
I think it's the reason that our position is that it's one of many verification techniques, so it's not the only verification technique. So to be called out
Yeah.
specifically, we could say including cozy, real ear, and just go down the entire long list of what exists.
They're not equivalent though.
They're considered verification techniques by definition. Whether they're equal to, that's I think where,
Well, there's-
some practitioners would disagree that they could do a verification technique by just saying something other than real ear. They don't use real ear. So to say that that's it's not an equivalent is I don't even agree.
Well,
Debatable.
one's objective and one's subjective. That real ear is an objective measure. Subjective is the cozy and
I agree with
so on.
with the definitions that way. What I'm trying to say is that verification techniques, the adoption of them, there's many various types, and I agree. I use real ear
Well,
measure myself.
I wouldn't
but
disagree with teaching them all of, any possible type of
I think that's what,
verification technique.
if we get too specific in the training, they should have a knowledge of maybe maybe multiple verification techniques. But what HHP has felt is that it does get to be a little bit too specific to call out that one in the
Well,
regulation.
it's probably the leading type, and the most
Currently.
objective.
There could be something different down the line, and we don't have to.
There could be. It's
So-
been around for 30 years, so I doubt it. Nothing has taken its place in 30 years,
Yeah.
so it's not likely. Almost 40.
I was just saying, real ear measures are well known to be the gold standard of fitting and verification of hearing aids. That's at the national level at every agency, whether that be in the audiology field or the hearing aid dispensing field, and that is something that is covered in the national materials even for hearing aid dispensers. And in fact, in Oregon, for example, you are required to perform real ear at the time of fitting audiology and hearing aid dispensing, and that's how they've made their regulatory, because they feel it is so important to the patient that real ear be performed to make sure it's safe, that we aren't over amplifying people and causing damage and so on. So it's an absolutely very important part of hearing aid dispensing, and it is something well within the scope of practice that is knowledge that's contained in the information that dispensers should have access to and use.
I wonder if there's going to defer to the latest occupational analysis, but that's like 6 or 8 years ago. So I wonder if this is something that has to look and see what is the current practice in the hearing aid dispensers occupational analysis. But if you go back to the most recent, I have a feeling that this is going to be a very low amount of that's currently adopted by the hearing aid dispensing community, according to that research. And things have changed in the last several years, availability and a lot of things like that.
I just think it's fairly essential that anybody who fits hearing aids is aware of it, knows about it. So we're not asking you to change anything in terms of practice or adoption of practice, but simply to inform. And I don't see the point of limiting education. Or
Yeah, if it's in the form of informing, I agree.
that's all. That's how I read that anyway. It's just asking them to provide knowledge of.
Yeah.
Would information of verification techniques be a better fit and more clear to the regulated public?
Rather than the word knowledge, because that sounds like practice.
Yeah, or provide information
Of techniques, yeah, provide information.
But don't they mean the same thing?
Kind of.
I mean, it's an inclusive statement. It's saying, it's almost one of those statements included but not limited to.
Okay, so am I hearing any desire to change subsection 10?
Yeah, if this is the understanding that knowledge is information, I'm fine with it.
I like what Paul just said, including but not limited to.
I would agree with that.
Yeah, that's a
statement.
great,
Yeah.
that's a great addition to it.
Okay. Does anybody want to make a motion then on that one?
Yeah, so, the same motion, you're saying 1399.118,
Okay.
and copy the same from the previous motion.
I did notice this does not say anything about otoscopic inspection of the ear in this list. I know it says it does default to numerous other things, but I think that is a very important thing to train.
Is it? Of course.
If you're voting, are you just voting on 10 or this whole section?
Oh, the whole section.
Okay,
So-
so yeah, I had a note to add the otoscopic inspection of the ear to this somewhere.
Maybe we thought that number 12 include, you know what I mean? But it's good to put it. Number 13, you want to put it? Number
Okay.
Number 13?
Number 13.
Yeah, because number 12 includes the inspection, but it's good to go and detail it.
All right, so, Amnon, I believe you had a motion to adopt the changes to 1399.118, which include adding a number 13, otoscopic inspection of the ear, and including the terms but not limited to in subsection 10, and to delegate to the executive officer the authority to promulgate the formal rulemaking and delegate the authority to make any technical or non-substantive changes. Is there a second?
Second.
Is there any, it's been moved and seconded, is there any further discussion from the board? Any comments from the public?
You're gonna hate me. I feel that 12 should be broken up to 2 different sections. The assessment of ear mold impression, but also we keep talking about creating an ear mold, making an impression itself as such an important thing. I don't know why it has to be lumped into one sentence with an and for those two. If it's more specific to make it assessment of ear mold impression, and another line be creation of ear mold impressions or making an ear mold impression. It was in a note, I just didn't see my. that.
Yeah, that semantic is up to the people to.
I
It's
guess
the same
it's a
thing,
matter of
just-
semantics, you're right, yeah.
It's I don't, whatever, but it's the same thing.
Amnon, do you want to change your motion based on that information or keep it the same?
Just for simplicity, keep it the same, because we can make
It's
item
in there,
14,
yeah.
but
It's there, you're right, yeah.
it's the same.
Okay.
So keep
Thank you, I apologize.
Yeah, you can vote now.
The what?
You can vote now.
Oh, okay. Rodney?
Yes.
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 Yeah, no. Okay, we'll move on to 119, which will be now titled Supervision. So we did discuss this one at length yesterday, but just to jog your memory. So in that first paragraph, based on HHP's comments, we added, the supervision shall be provided by the supervising dispenser for the duration of the trainee applicant's temporary license at all times while the trainee applicant is engaged in the practice of fitting and selling hearing aids, which again ties back to the scope of practice that is defined in your Practice Act. We discussed how that might alleviate some of the concern about clerical work and lunch breaks and things like that, where someone would have to be on site. We started to get into the discussion about the next sentence, or the sentence after that, sorry, but supervision shall mean either direct or immediate supervision, and supervision shall not include supervision by telephonic or electronic means. So I think, and we had a very robust discussion yesterday about that, and
Possibly we'll do it again today.
Yep, okay. So whether or not the board, believes that public protection is served by carving out this third exception, a third level of indirect supervision, which would not be physically present, or whether or not physical presence at the location, maybe not over the shoulder, but at the location where the trainee is, and is performing services that are part of the practice of fitting and selling hearing aids. What serves public protection and what's necessary there.
So we have to craft now the task that fall under each supervision. Because here it says here supervision should mean either direct supervision or immediate supervision. So
Right.
what
Because at the last board meeting, the board gave clear direction that physically present at the location, and that the board did not feel
Yeah,
that,
we put it at the same room.
yes, that
Right.
they did not want any sort of, at a separate location, supervising by telephonic or
Right.
other electronic means. But we did have a discussion as to whether or not that was the appropriate way to approach this
So
regulation.
I think that we have two extremes. One is taking an ear mold impression, and which include looking in the ear, should be immediate supervision at all times. And then on the other side, replacing battery or replacing filter or cleaning the hearing aid could be unsupervised. And in between, there's some jobs that maybe will be able to do it part-time. Let's say here the 90 days come. If somebody train a trainee for 3 months how to do hair and bone test, maybe he can do it under not immediate supervision, but supervision, doing the rest of of his supervision time to do the test. So that's what I think we're standing here, is just to define on these three categories.
So I do want to answer your question. I just realized where the 90 days comes from.
Yeah.
It comes
Oh.
from SLIPUS.
From where?
SLIPUS.
From where?
The
I-
SLIPUS.
Let me put my hearing.
Speech
Nah.
Speech pathology.
Speech pathology.
Sleep. Okay, you know the S and the F are not.
I apologize. So that's where it comes from. They have it in their regulations that during the first 90 days, the supervisor shall provide immediate supervision at least 20 times per week.
Okay.
The work schedule.
Okay, so here we talk about it. So maybe after 90 days, a trainee will be able to do the hearing test, not under immediate supervision, but under
Direct,
supervision.
Yeah.
And but the ear impression would be immediate all the time, and the cleaning and batteries replacement, stuff like this, could be unsupervised. I mean, not in the same facility. It could be even remote.
Emma, it sounds like that second, or that last category you're talking about is actually direct supervision.
No, what the last I'm talking about? You're talking about
What
battery
about-
replacement?
No, that's unsupervised.
That's supervised. That's supervised, but supervised it means that you don't have to be in the same state even.
So we're back to
The
in
one
Yeah.
with the
three
battery
categories.
changes and
Indirect
answering the
supervision,
telephone.
indirect.
Yeah, I mean,
It's unsupervised.
yeah. So what do you call direct supervision? The hearing
Where the
test?
supervisor is in the building, but not
On
in the same
premises,
room.
yeah.
For the hearing test?
No, that's immediate.
No, hearing test, we said immediate, the ear impression. Okay.
No, so
That's defined in
D.
D.
Yeah, D for that.
That's defined in D.
Yeah,
These are the same definitions.
yeah,
that
yeah,
essentially use.
I know this,
These are
but
the
I
same
think
definition.
maybe we talk about maybe changing to remove the audiometric test from immediate supervision to maybe partially, I mean, like 90 days immediate supervision, and then the rest could be direct supervision.
Yeah, on premises, but not
Yeah.
over the shoulder. Yeah, I think we're talking about the same thing.
So I had in my notes that we had this third category, which Paul doesn't want to go to, but we had any activity unrelated to fitting and selling of hearing aids.
That's already built in. If that's the case, and I think that's sort of what we were grappling with yesterday, if that is the case, then you don't need that third level because it's already built into the regulation. If you're not engaged in the practice of fitting and selling hearing aids, then you don't need to be supervised.
Okay.
But if you are engaged in the practice of fitting and selling hearing aids, then you need to fall into one of these two categories. And that will be dependent on the type, which is defined in D, and if we need to make changes to that, changes can be made to that. And then also in E and F. So after 90 days, or whatever the threshold the board decides, then the other activities are, you don't have to be over the shoulder, but
Yeah.
you have to be on location.
Right.
But if it's not within the scope of fitting and selling hearing aids, the supervisor can be wherever.
Yeah.
And so if
Okay.
that is the
Yeah.
case, then that is how it's already written.
Agree.
So are you saying we don't have to mention indirect supervision?
Yes. I don't think so. I mean, if you would like to use that buzzword, I am happy to insert it in.
Looking at the board's definition of there is a current period of time that's going to exist once this is approved as well, and that is from the point in time where a candidate has received a passing score on their practicum, and then are in the waiting period for filing of their license. They've proven that they can do all the tasks, and at this current point, they're under director or immediate supervision for the waiting period, which can take it can take a couple of months for that to get done from the time that.
No, it doesn't take, well, for
I've,
what,
I've seen over the years it's taken longer or shorter, but it's not immediate on that.
we
It
don't
can take a
have
while.
we don't have any provisions for licensure in any category where we change any requirements. You're either licensed or you're not, and that, because a lot of times a student graduates from their class, passes the exam and meets the requirements, but they still have to get licensed. But if you see our licensing timeframes, we don't have issues with hearing aid dispensers as we do in some other areas. That's handled by a different desk.
What is the time between the person get his passing score on the practical, which is the last exam, and get the actual physical license?
Brian, can you give me an idea of what that is? I have it in my report, but we could get more accurate, up
It
to
said
date.
current, but I didn't see that it had like a time frame. I'm not sure what current exactly meant.
We have a performance-based budget, and it's 3 weeks. But I can tell you, as soon as we give out the scores on the practical exam, I can tell you, the applicants get it right back in, and within a week it's processed.
Yeah, but you said 3 weeks.
Well, that's our time frame, but we do it quicker.
Now, do you put it right away on your website?
As soon as they're licensed, yes.
No, when they pass how long it takes when they pass the practical, then they look at the website, or anybody, the consumer, they look at the website and see
When they're
that.
licensed.
Yeah, they have to put in an application for permanent licensure. Once we get that in,
Oh,
it's usually,
They put the application before the test or after? the
when they
test?
get their score results in the mail on the practical exam.
At that time, they put the application for license?
Yes, because that's part of what we send them.
And this take only 3 weeks before they?
That's our maximum, but I can tell you, it's within a week. It's a quick turnaround, because all we're getting is their application and their $280 fee,
Yeah, okay.
and that's it.
Oh, okay, and then you send them the license and you put it on the website?
Yes, that's
On
within
the same
24
time?
hours.
And just to clarify, I just wanted to point out that we don't take as long to do the hearing aid dispenser license application processing.
Yeah.
But I also want to point out that even if we did, we don't have special supervision provisions for waiting, for knowing that you passed the exam and not having your license processed yet. It's either you're licensed or you're not. You're either a trainee or you're not.
Yeah.
So,
So it doesn't mean that they can't practice, it means they continue as a trainee until
Right.
they actually have the
Yeah, I
license.
know,
It's not
but
like all of a sudden
I
you
know
stop
what
working.
is the
Correct, yeah.
question here. The person got in the mail that he passed the practical exam.
Right.
Which is the last exam. And it's look weird to people, why do I have to be over his shoulder? He is already.
the same reason, the same reason, yeah.
This
is a ridiculous complaint.
Yes,
Huh?
it's frivolous.
This is a ridiculous
Yeah.
complaint.
Yeah.
My residents have to wait 6 months from when they pass their step 3 exam to when
Yeah.
they get their license and are able to prescribe medications.
Oh.
I have to wait for them, for 6 months for them.
So if this is something that the whole this is in the whole professions, we will not change it for dispensers.
Well, like I said, they can still work and get paid, they're just.
No, I know. It's not about them, it's about the supervisor.
Oh, well,
Supervisor.
that's part.
I'm supervising
that's-
somebody
that's
that
the
is a
supervisor.
dispenser.
To get their
Yeah, and the only reason I was bringing it up is because I know Lisa works really hard to get people licensed right away. I sometimes try to pull her away to do something else, and she won't budge. So we know that we're getting.
She
used
knows
to-
the
That's right.
And probably it's help us get the $280 faster.
But I have no other comments on indirect supervision or any opposition toward that myself, personally.
So I guess my next question is focused on subsection D. I heard some conversation about perhaps changing this list that is here that requires immediate supervision, which means over the shoulder throughout the duration of the trainee's license. Are there any changes to that one?
we can go to the next one. I can try to have that later.
I believe that we discussed about maybe moving the last two items to hearing aid programming and audiometric evaluations to be moved from immediate to direct supervision after 90 days.
Any,
That's all.
I know we came up with 90 days because of the SLIPA regulations, but does that mean the same in the world of hearing aid dispensing?
There's never been anything the only thing 90 days would be a new hire in their probationary period that I've seen in my.
So that's what I was gonna address. So I think something that, Joe, you talked about is the issue of competency, and competency varies across individuals. So, one thing that I was thinking we could do, which is a little arbitrary as well, but to say a minimum of 90 days or when the supervisor determines competency.
If you allow that, supervisors all vary as well. I know.
Right, I know, but I mean, that's a little bit more, so at least 90
making it a
days
minimum.
or until the supervisor determines competency, at least, let's,
If you put this or, it would be 1 day. I'm
I
telling you,
said
and
at
everybody.
least 90 days or until.
No, yeah.
Which means you gotta do it for 90 days.
Yeah.
And
Well, you
then.
said or.
Oh, okay, and,
And-
well, okay, how can we word this? So,
Whatever time.
Minimum of 90 days.
at minimum,
But
90
that-
days.
I think you have it right, a minimum of 90
90
days
days
or
until
until the supervisor
right,
determines
determines
proficiency.
Yeah, so
That's
at
90 days
minimum
or
means
longer.
at minimum, you
Yeah.
gotta do it 90 days.
Yeah.
And it can be longer if the supervisor determines there is not competency.
Yeah.
So at least we're getting at that issue a little bit.
Yeah.
It's better than not saying anything
It
about
stretches it out
competency.
some too. I mean, it gives you.
Well, it gives the supervisor the option.
Yes.
yeah,
It's true.
for the telesupervision for SLIPAs that we just did, there was a portion of it where there was a portion of it where the supervisor had to determine that the services to be provided could be supervised by some telesupervision means, but also that the trainee or I'm blanking on the actual profession that we were working with in their designation, but that person was able to complete the tasks without needing the supervisor physically present.
No, I'm just wondering, I'm asking a different question, I think.
If we put that onus on the supervisors?
Yeah, that's what's bothering me. Are there other language in here that says supervisors have to determine competency and therefore withdraw their supervision level?
So it is kind of like that. If for telesupervision, they determine that the particular individual is not competent enough to perform the services without having someone physically present, then they make that determination. They have to make the determination that.
Is that the only designation as telepractice?
I actually think it's a common situation in other healing arts professions, because what the supervisor is doing, we're putting requirements on the supervisor, and the supervisor is actually saying, I am going to be responsible for this training.
Yeah.
So we actually, if something goes wrong, that supervisor is responsible. So they should have a right to determine whether that person can move on to.
Yeah,
Okay.
because
Yeah, I
I
agree
can't
completely.
imagine if I'm supervising a trainee in immediate supervision for 3 months, I'm over his shoulder or next table, and he still cannot do a hearing test. I don't know how long he can be a trainee anymore. If somebody after immediate supervision of 3 months cannot perform hearing tests without me being in the room, I don't think he should be in this business.
I would agree.
Well, that way you prevent a situation in which
Yeah.
a trainee maybe does something negligent and the trainee says, well, I served I trained for 90 days, so I was good to go. And it also then puts the responsibility back on the supervisor to make sure that those practices are being
Yeah,
considered.
and I think every violation of the trainee, whatever, is the responsibility of both people, him and the supervisor, right? If there's any violation.
Supervisor's responsible, I believe.
Yeah.
By statute,
It
it is the
is.
supervisor's responsibility.
their license.
They are,
Both.
yes, they are responsible for the
Yeah.
actions of the trainee.
Yep.
Okay, so adding a minimum of 90 days until the supervisor determines competency. Was there any opposition to moving hearing aid programming and audiometric evaluations to the category of subsection F? So taking them out of D? We wouldn't be moving them to F, but just taking them out of D, and then they would become tasks that could be performed under direct supervision after 90 days or when the supervisor determines
Right, it's
competency.
Okay.
Yes.
Yeah, I'm good with that.
Okay.
It's not or, right? Or it's not or determines competency.
It's a minimum.
Until such a, yeah, so minimum 90 days.
A minimum is already established as a minimum. And
But
then,
no, it is confusing language.
you said or.
It is confusing language.
And until, how about and?
Okay.
Does that change it? I think so,
Yeah.
yeah.
And I understand the policy here of what you're trying to achieve. So if you delegate to the executive officer the authority to make these technical non-substantive changes, we can wordsmith it to make sure that it fits what the board is saying today. And we understand the end goal that you're trying to achieve. And so if we need to wordsmith, by delegating that authority, we can wordsmith to make it, ensure that it's proper.
But I think the word and handles that.
I was looking at it too.
Yeah, I think and handles it, but we'll let you wordsmith.
Okay.
I have a question with the, if otoscopic inspection has any way to move to direct supervision at that point in time too, partly because you are looking over the shoulder of the person doing the task, but it sounds like you would have to repeat the task yourself because you can't see what that person is seeing at some point in time. If you're over the shoulder of someone performing otoscopy, you can see their techniques and the way they're doing it, but you would still have to then do a second otoscopic examination yourself and determine through training whether or not that person is assessing the ear at least correctly. At some point in time with direct supervision, you could have the person look down an ear and you could still see technique, but you're not over the shoulder. There's a point in time where watching technique and rechecking every single ear, I think, becomes somewhat redundant.
Except that the immediate supervision, it doesn't necessarily, it's not spelling out unless we changed it to say that it's over the shoulder. Did we do
It's
that?
immediate.
We said the
Immediate
same rule.
supervision.
Immediate.
In the
If
same
you
rule,
are-
yeah.
Immediate.
My thoughts are just
It's-
if you think about the process of doing otoscopy, video otoscopy is great because we both can see on
See
the
at the same
screen, but
time, right.
if someone uses an otoscope and looks down an ear, they have to basically give you an assessment of what they see. We can't diagnose, so we have to actually talk about there being, something or nothing. And then ultimately the trainer's gonna have to look as well down the ear, and that's training, that's why we do it. But there comes a point in time where that shouldn't require that immediate supervision, because when you've seen a lot of good ears, you can kind of tell what a bad one looks like, I think. There's a little less room for there to be a danger if you're using proper techniques and everything along those lines. So I would argue that otoscopic examination should also be included with audiometric and hearing aid programming under direct, not by any means indirect. But I pose that.
Yeah, there is something, what you're saying is because when you perform audiometric tests, not the hearing aid dispensing, you first have to look at the ear. So if we will not take it into the category of the 90 days, it means that every time the person for 6 months will have to be immediate supervision because this is part of the test.
Correct.
Is there any way to craft it so that the trainee has to inform the supervisor of anything that's abnormal? Yeah, because most of the time it's no big deal. They can look in there and move on. They don't need supervision. But they have to recognize certain things that not everybody is trained to recognize, as Rod can attest to, I'm sure.
But see, that's the whole beauty of having it being immediate, is that if the supervisor's in the room, then the trainee is more likely to bring something up if they have any question at all, whereas if the supervisor's not in the room and if the trainee has some doubt, then they may be less apt to try and find the supervisor. If the supervisor's already there, the trainee, if there's any doubt, can just say, well, you take a look.
But what I'm thinking is like the supervisor can be in the same building. I'm talking about after 90 days. We're talking about 90 days immediate supervision.
I
But
just don't
if
think
it-
it's safe for the
Huh?
patient.
90 days immediate supervision. And
Can you repeat that, Rod? I didn't hear what you just said.
Well,
No,
I
about the
think
patient safety.
I think that, I mean, if the whole question is, if you're concerned if a trainee, if you're not sure if a trainee is equipped to recognize an abnormal from a normal finding, then that trainee is gonna be more apt to call upon their supervisor to double check their work if the supervisor is in the room. If the supervisor is in the building but not in the room, then
but
they're gonna be less apt to do it.
I know, but
even after the 90 days.
assume that after 90 days of immediate supervision, the trainee will start getting an idea what's a normal ear and what's not.
But
And
we-
he's not, and by the way,
Yeah, so that's
And
what we
this is
assume.
just
So-
for the
so you
purpose
just
of
have to
hearing
wonder
test.
What you have to ask, so you have to ask within your profession, is that an acceptable threshold for your profession, is
I
90
think,
days?
but
My
I
sense is
tell
that
you, I
it's
tell you
not.
why it's I think it's acceptable, because this is for the purpose of making a hearing test, not a hearing aid. Now, if you need a hearing aid to make, then the supervisor must look at the ear. For every time that the person gonna dispense hearing aids, there's throughout the whole period of training, it's immediate supervision. So every time a person will say, okay, now we're gonna take an ear mold impression, the supervisor will be in the room and look at the ear
But you
beside the
haven't made that
trainee. So this
distinction
is
in the
12,
You haven't made that distinction, you haven't made that distinction in the regulations, you haven't
why?
made that distinction.
Don't we have, taking
haven't
an
made
ear
that
mold
distinction
impression
between-
is immediate supervision throughout the time of training?
You haven't made the distinction between otoscopy for audiometry and otoscopy for hearing aid fitting.
So we have to make, if we didn't, we have to make
But
it.
that's just gonna add, I would argue that that's just going to make the regulations more and more granular, and I think that's the wrong way to go.
Yeah, and also we can add the "and" until the supervisor determines competency again for
Again,
that.
within F.
Yes, exactly.
Yeah.
And then that helps us.
For a
But-
minimum
but
of 90
still,
days,
I
the
mean,
same.
well, it's with the three members on the board, my sense is that, that part, should stay within the immediate section and not the direct section, so that's.
Yeah, but once you do this,
That's-
you are
Well, I have a-
prohibiting people of doing hearing tests.
Let me throw in a couple of comments. I have a lot of referrals from primary care physicians as well as pediatricians. And they claim that the ear canal is fine, no problem, prior to and after audiometric evaluation. And then clearly I'll get a conductive loss, I'll get abnormal temps. Clearly they don't know what they're looking at because they make these mistakes. ENTs almost never make them, but those kind of physicians do. Secondly, I've been doing this for several decades, and the other day I saw somebody who, I took an ear impression, looked in their ear, and all of a sudden there was a blood blister. And it turned out that this individual was on blood thinners, several, that created this situation. And I'm very experienced at doing it, looking at it, thinking everything is just fine. So 90 days is just a drop in that bucket in terms of otoscopy and the things that can go wrong and the things that even educated, experienced people will run into.
Yeah, but you took an ear mold impression, you said, right? I'm not talking about ear mold. I'm talking just looking at the ear. Just looking at the
But
ear
I'm
for
talking
a
about
purpose
these-
of hearing test, not for a purpose
I'm
of
talking about
hearing it.
physicians who are unable to determine what they're looking at with
Yeah.
years of experience, let alone 90 days.
It becomes.
Yeah, but-
And not for the
Once you start
purposes
to
of
make
fitting a
that
hearing aid
kind of
just because they're looking.
recommendations, then it
Do
becomes
you have,
hard to
let me
enforce.
ask you this, if in your
How are you
profession
gonna-
now you
how are
have
you gonna
audiology
enforce that?
aid that can do hearing test in industrial stuff?
No, I think they can do just about anything. That's
No, they
another-
cannot do sell hearing aids, right?
That's right.
Right, but they can do hearing tests, right? And what is their training, how long their training in order to do the
I
test?
know, I'd have to look back in
No,
here and
but
see what it is.
just briefly, I mean, how, by the way, those people go and look in the ear before they do the test in this industrial complex?
I don't work in industry, so I don't know
No, I mean,
about that in
audiology
particular, but I
aid.
would think so. I would think they would.
So I wonder,
But
just
there,
to find out an
direct,
idea.
that's immediate supervision situation.
Yeah.
Those people aren't left to themselves.
No, I know, but those aids are immediate supervision all the time? Oh, so they are going to go and do a screening in a factory with an audiologist, and the audiologist in the same
I
room?
can't
so-
speak to factories. I
I'm-
don't know.
So I can read you this, what the
Yeah,
statute says.
right.
It says that an audiology aid means any person meeting the minimum requirements established by the board. An audiology aid may not perform any function that constitutes the practice of audiology unless he or she is under the supervision of an audiologist. The board may by regulation accept certain functions performed by an industrial audiology aid from supervision, provided that his or her employer has established a set of procedures or protocols that the aid shall follow in performing these functions.
But the supervision is not immediate supervision.
No.
So here.
It's not defined.
Maybe it should be.
Yeah, I mean, so,
I agree.
It should be.
Sounds like a great future agenda.
yeah.
I don't want to get off topic, but I just want to, I want to stress the importance of that. I think that's something that we need to look at. We've had a couple of different legal counsels that have advised us on this, and it may require a statutory change, but I do think that, we look at all these gaps that we have to fill, that's definitely one that we need to look at.
And I just want to make a comment that I'm not comfortable with otoscopic evaluations being under direct supervision, because if you think about a medical assistant who is working under direct supervision of a physician, an MD, they're doing hearing screenings and things like that all the time, and the MD is the one who's looking in the ears, and they're not, MAs, I'm not sure what training they have. It's like a 9-month training at a college, and they're, they have degrees, and they're still working under immediate supervision of a physician. So I think 90 days for a hearing aid dispenser trainee is certainly not enough for direct.
My argument only past that is the step of the process that it's happening. In the beginning of looking down somebody's ears prior to audiometric assessment, you then have audiometric assessment as your next step, and the trainer is required to look at the hearing test and see what's happening, to see any kind of conductive issues that are showing up on said test. When it comes time to make impressions for a hearing aid, there is immediate supervision of that process, so it does change some. But otoscopy would be, it's the same ear from the beginning to that point in time too. I'm a proctor, I can't speak to that, but I would suggest looking at your own stuff when it comes to to that, if you're able to, because I think the opinions are kind of coming out a little different than what the general consensus has been on this exact topic, so.
We're in D. Maybe the board can chew on that for a little bit longer. Anything about the 90 days other than the minimum 90 days, is there?
Competence by the supervisor.
Yeah, the competency
Yeah, but
part.
If we will not allow to move from immediate supervision to direct supervision after 90 days for otoscopic procedure, then we are prohibiting from them to do the hearing test as well. And this is a big burden.
Oh, well. Sorry.
No, I was just, so I train AUD students, and I would go in there with them, look in the ear, sit through the case history, and I'm comfortable leaving them to do a hearing test. I don't have to be over their shoulder doing a hearing test, but I am going to be looking behind them in the ear canal to make sure that it's clear and discuss what I see, or have them discuss what they see.
So for how long do you look at the ear canal for every student? I mean, more than 3 months?
Well, obviously it depends on the student, and I'm making the assessment of clinical competence, but they're most of the time coming to me with 4 years of postgraduate or post baccalaureate work, so they've had, a lot of them are skilled, and so it's variable.
We're trying to be practical here, so.
I don't think
understand.
that the nature of supervision and training is always practical.
Just to add to Dr. Cooper's report there, seeing every patient every time, not just AUD students. I have trained now 3 dispensers in my practice, and will continue to do so. I have a student every single day in my office, 5 days a week. None of them work. And I think that that's been a real deficiency in how we treat training, both maybe in audiology program students, but also in the field of dispensing, is that we're hiring people as trainees to work for us, as opposed to hiring them on or letting them be supervised and actually teaching them. They're not there to do work, they're there to learn. So it does take a lot of time on the end of the person doing the training, and I think it is very important that you continue to peek at all of your students. None of them are licensed, right? So I think saying it's onerous and cumbersome to double check otoscopy or be looking in on the 15 seconds it takes to do otoscopy and saying that that's an impossible thing to do is kind of ridiculous.
Maybe if you have 3 students that you're supervising, that's could be a problem.
So, I'll just move on to the next part or unless the board wants to vote on this particular issue. There seems to be some division, so I don't know how the board wants to move forward with this. If they want to have a motion and a vote on subsection D, or if we want to continue on and have somebody put a motion forward that includes the language that they want, or...
one thing that maybe we can separate is that the otoscopic procedure versus the audiometric test. I mean, let's assume that the supervisor over the shoulder and look with the trainee on the otoscope, but then goes to his office and the trainee will do the audiometric test. In this case, after 90 days, the trainee will be able to perform just the test without the immediate supervision. So the otoscopic procedure will be immediate throughout the training, but the audiometric test can be direct supervision.
And I don't know enough, I apologize, but, so we did remove audiometric evaluations, is that what you're
Yeah, but
referring to?
yeah. Uh-huh.
Okay, so in D, there's the remover of hearing aid
Oh, and
programming
yeah,
audiometric
otoscopic
evaluation.
inspection of the ear, so it's still remaining. Okay, so
In D,
that's it.
And then we moved, yeah.
So, yeah, okay, so we removed to the 90 days the audiometric evaluation, and I think hearing aid programming also.
Yeah,
Right.
yes, that's what my
Yeah,
notes reflect.
okay.
Okay, so then it sounds like we can move on. We've covered subsection E, so we'll move on to F, which we have sort of discussed too, but I did want to say that the red portions of it were again in response to HHP's comments, which were warranted and in my opinion, and so it just adds the services in connection with the practice of fitting and selling hearing aids, which again just shows that supervision is only required when you are fitting and you're practicing, when you are using that license. So, and then HHP also had a comment to subsection I, which I agree with, but for different reasons. I think they mentioned that it was vague and sort of in contention with another portion of the regulation, and in my opinion, it's just excessive and redundant because the statute already provides for it, as does the regulation. So I just suggested to remove it completely. It's not already in your regulation, it was something that was added. But I don't think that legally it's necessary because it's already there. And then just another quick note is that in adding the section 2538.11 into your reference sections, because that is the statute that spells out the practice of fitting and selling hearing aids.
Could you go back to F for just a second and restate what you said about the sentence, the supervising dispensers shall provide direct supervision for all other services in connection with the practice of fitting and selling hearing aids. What did you just say about it?
So it just said services in prior versions. And
so not in connection with?
not in
all
connection with
other
the practice of
services.
fitting and selling hearing aids. So that was vague in terms of what that meant and what supervision would be required. And it begged the question, what about scheduling, answering phones, that sort of thing?
But this, all other services, so what do you, like answering the phone? Is all other services in connection with the practice of fitting and selling hearing aids? Why does that statement have to be there?
It's saying after the initial 90 calendar days, with the exception of those services provided in subsection D, which is the one we just talked about, which require immediate supervision for the duration of the trainee applicant's temporary license, the supervisor dispenser shall provide direct supervision for all other. So I guess the reference to other is, it's not those that are in D, it's everything else. Any other service that doesn't fall within otoscopic inspection, ear impressions for hearing aids or ear molds.
So the tube change, the battery change, troubleshooting,
Yeah.
all that?
Mm-hmm.
Okay.
That would also include hearing aid programming and audiometric evaluations, because we took that out.
Mhm.
That concludes my portion.
We should have
your
I feel like I should throw flowers at you or something like that.
Do you want a quick
No,
I feel like you said
I, if anyone would like a motion, to throw out a motion.
It'll come back to us. We'll see this
Thank you,
again.
Joe.
Thank you.
Are we gonna move to accept the last section then?
If you choose to.
Oh, I got the inclusive, how do you, how inclusive?
Oh, it's a section,
Move for everything in this stuff.
Oh, I
Right.
just,
Right.
let me just say a quick note, based on yesterday's conversations about direct supervision, we did add, so it's for direct supervision, we'd be using the first, or option 2, which is in yellow.
Okay.
But we would be adding, into it, the very same room,
Yes.
which we discussed yesterday. And then, for immediate supervision, we would be using option 3, which is, I know I told you we wouldn't have to look at the blue, but we do, I'm sorry. So immediate supervision means, so I'll read it, means that the supervising dispenser is physically present, immediately available. Oh,
Right.
sorry, wrong one. We would be adding in the same room to that one. So immediate supervision means that the supervising dispenser is physically present in the same room and immediately available to give aid, direction, and instruction to the training applicant. So that is that one, and so very same room, I need to change minutes there. And direct supervision means the supervising dispenser is on site and in close proximity to where the training applicant is engaged in the practice of fitting and selling hearing aids. And the dispenser is available at all times to provide observation, guidance, and assistance to the training applicant. So,
I'm sorry, did you put rendering services for fitting and selling of hearing
I
aids?
changed rendering services and
To-
changed it to practice of fitting and selling hearing
Okay,
aids
okay.
to be consistent with the rest of the
Yeah.
regulations and to address HHP's concerns, which were valid.
Yep.
Is there a motion on
Yeah.
1399-199?
Yeah, I move to whateve you want.
Oh. Okay, so, to approve section 1399.119 with the discussed amendments to it, to delegate to the executive officer the authority to promulgate the formal rulemaking, and also to delegate to the executive officer to make any technical or non-substantive changes.
So moved.
Second.
It's been moved and seconded. Is there any further discussion from members of the board? Okay, any comments from the public? If not, we'll call for the vote.
Yes.
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 I was going to ask, would people like to take a very quick break?
But really quick.
Really quick.
Really quick. Run, 5 minutes. Boy, this is.
I was thinking, we're all like, microphone police.
And Marcia, I understand that you're addressing this issue.
Okay, well, several months ago, the board looked at the notion of locked hearing aids, that is, hearing aids being fitted with proprietary software that's only available at certain outlets, could serve as a consumer protection issue, a lack of access, if you're unable to go back, or moved away, or anything like that, or your provider went out of business, and so on. But we recognize that there may be an issue, but we didn't go anywhere with it. So we're bringing that back again at this point, thinking that we'd like to consider whether there should be some disclaimer on the delivery receipt for those companies that do have locked hearing aids to inform the consumer that they're purchasing something that they either have to return to that particular location or an outlet from the same company in order to have their hearing aids programmed. So the consumers are aware of that before they purchase them, or as they're, whatever, during their 45 days, they can consider that. Anyway, that's where that came up. So it seems not a bad idea. There's only, I don't know, it looks like there's maybe 8 or so companies that fall into this category.
I don't know that list is exhaustive. So some of the.
I did speak to some manufacturers asking for others, and the only other one was actually not proprietary per se, but just a very small company that doesn't have many providers.
Yeah, some of the ones listed on here, like Audiology, for example, is a common group that audiologists might join as a private practice network. Once they join this Audiology group, they can then sell the proprietary Audiology hearing aid, AGX, blah, blah, blah. There's all these weird hearing aids that are made by major manufacturers but are then locked and private labeled as this Audiology brand of hearing aids. So even though there's only maybe a handful of companies doing it, it actually translates into could be a large number of offices participating in it. I think I brought this up a couple years ago, actually, maybe, or at least a year ago. The first time for me in Elk Grove, where I practice, it was a McDonald's issue. McDonald's private label locked all their hearing aids, and when they went out of business, all these patients were coming in, and I could not help them. And they were livid when they found out that they could not get service on their hearing aids, they could not get them repaired, they could not get them programmed, and that the only way that they could do anything to change their hearing aid would be to get a new one. In some cases, the manufacturers will unlock the devices if you can find out who the parent manufacturer is of these and send them out. In those cases, the patient is now without hearing aids for a given period of time. They potentially are paying money for repairs, because it's considered a repair if it's out of warranty. And in my case with McDonald's, I was actually told by the parent company that they would not unlock the devices, and they were bound under contract from their contract they had at that time with McDonald's to disallow for any devices to be unlocked. So for me, in my patient area, that was a huge issue, and consumers and patients are flabbergasted in most cases, in my experience, to learn that they have these devices. They don't know. It's like going to buy your car at the Chevy dealership and finding out you can only have it ever get your oil changed at Chevy and you can't go to Jiffy Lube. Like, they don't understand why that is happening. So they are clearly uninformed of it. So I am asking that we consider like an informed consent type of statement, something where the patient is acknowledging, the consumer is acknowledging that they understand they have limited capability to receive service on their devices that they're purchasing.
Would that also be, I don't know how many people are buying hearing aids online, that are they usually ones that could be programmed by anybody if they were willing? Or,
No.
or are they special label also?
Yeah, as far as I know, and I'm sure Joe has some experience too. As far as I know, the online stuff, MD hearing aids would be one that comes to mind. Those are unique to MD hearing aids and can only be programmed by MD hearing aids. That said, I don't know. We have a whole host of issues with online hearing aids. I don't know that we can address it.
Or high health innovation.
Or high health innovations. That would be a whole. Yep, mail order only. I mean, all the ones that are ordered out of magazines and so on. But I don't know what that has to do. What we can do about that.
Yeah, I don't know. We had some rule against not online hearing aids, but catalog hearing aids being sold in California.
There's a restriction, yes.
I'm sorry, I missed that.
Just that we have a regulation regarding hearing aids not being dispensed by a licensed Californian.
Yeah, I'm not sure how they
So
get
does
around.
HHP have an opinion about having some disclaimer? I invite you to.
We
our membership is varied in all aspects of this, so we really don't have a one direction or the other opinion, and are really leaning on the board for some guidance as to how they would like to proceed with this. My comments about the mail order type system is, I don't believe anything with it will do will bind any mail order systems for creating that consent, and most of them are, whenever people walk in, that we can't do anything to fix the hearing aid usually.
Well, the ones I've seen, they do come in with something that I perhaps do have the software with, I just won't help them.
There's one manufacturer that's not unlocked, but they do, you'll see the sales, well, I'm not sure, Unitron, I'm not sure if their stuff that gets sold over the internet, if it's locked, but I don't believe so. We have usually availability of software to program that. But again, not the desire to.
I have the software.
I have a question. If we take a small rural city that has, for example, 4 practices, one is a Starkey dealer, one is a Auticon, one is Widex, one is Unitron, and a person buy one of them, and it's not considered by us a lock hearing aid, but practically he has to go to the same office. He cannot go to the other 3 because the other 3 might say, you know what, we don't have the software to go.
I disagree. The software's available.
No.
Available. Yeah.
And most of us fit multiple brands.
Yeah.
We don't just fit, we're not just an Oticon office or a
Yeah, the average
Unitron.
computer's gonna have just, I'd say even, I have probably a computer with
Yeah.
10 different programs.
I do too, at least that.
Yeah.
Right, and with the lock devices, the issue is, even if you as the provider want to help the patient and you want to be able to take over their care, or they move from another area, their office closed, whatever the case may be, you cannot. I mean, you cannot. There is no way. It's proprietary software.
So it appears to be a consumer access issue, and I think just informing them of this situation is probably a good consumer protection activity.
Marcia, when you said 8 companies, is that 8 hearing aid dispensing companies, or is that 8 manufacturers, or is that a combination of that?
They're manufacturers in my view, but then they have franchised offices that do the provision. Like Beltone, for example.
Or Miracle Air.
Yeah, but we regulate only the providers, not the manufacturers.
So
The board.
then, is it within our jurisdiction as a state agency to regulate that kind of thing?
Well, we certainly regulate the delivery receipt and what has to be on it. So I would think that this is
Because it's
an
the
element of
licensee
that.
dispensing that hearing aid.
Yeah.
So then we would be able to regulate how that device is given to the patient, at least on the delivery end, if not on the manufacturer's end.
I don't know if the manufacturers provide the delivery receipts for Beltone and Miracle Ear, I assume they do, and
I am actually, I am
Yeah, I
not
don't
aware of
know.
that. Yeah.
Right, so, I mean, another example is Costco, Sam's Club, Audubell. I mean, so there are a lot of big places, and I think, my interpretation would be, you know, if the state of California, the licensing board decides that this is a consumer protection issue, that asking for an informed consent, we're not restricting companies' ability to do business in any way, nor are we asking that they be having some onerous, you know, regulation. It's just a matter of, it seems as though the people who work at such places, the providers, are not informing the patient that this is what's happening, that the consumer is not being informed that they are limited in access to care after purchasing a device at these places. And so we're just asking that they be informed. We're not asking that they be disallowed.
Would the best way be to identify the companies that are doing it and then force them to notify their patients, or would it be to have all dispensing companies and dispensers and dispensing audiologists post on their place of business that it is possible that hearing aids can be locked, and that you should check with your hearing aid dispenser about compatibility, or however it was gonna be worded prior to purchase, or just kind of like how there's a plaque outside my office that, this doctor is regulated by the medical board. If you have complaints, then go call this number. If this hearing aid doesn't work, then it may be because it's locked, and you should, before you buy it, you should talk to your hearing aid dispenser to ensure compatibility prior to purchase, or something like that.
I think it should be on the receipt, not on somewhere on the
Yeah.
board, on the wall, because people will not.
Should it just be a
On the
a
purchase
general
order.
People don't
form,
put
like,
much attention to.
certain font size? Should that
Yes.
be like regulated
Well,
as
we
part of
could- we asked
every receipt?
About a year or so ago, that we had to have an extra form if somebody's trial had to be extended because the hearing aid to go be remade or something like that. We had to have a separate form that people have to, I think HHP supported that, if not authored it. And we do it. We have that extra form. We could ask them to just include a sentence on their existing delivery receipt, so they don't have to have a separate form.
We have statute in the civil code regarding the warranty of a hearing aid. And then we have receipt requirements in business and professions code. So I imagine it's the business and profession code that would have to be amended if we wanted to have some type of disclosure requirement.
And I guess my other question is, if a hearing aid dispenser does not disclose it, would it be reasonable to hold that hearing aid dispenser liable for some type of negligence for having not disclosed it? And would we, as a board, try to enforce
Yeah, I
that
think,
sort of negligence?
I think there should be some penalty to the dispenser if he does not disclose it. Then, and a patient complain after 6 months or whatever, then he will have to return the money, not of 45 days, but there's no limit for returning the money if this occurs without the disclosure in the receipt.
Is that a statutory change involved?
Yes.
Oh, ew.
Anything else I should?
Kevin. So does that better for professional organization to try to bring legislation, or we have an omnibus?
It's a statute.
Well, it wouldn't likely be an omnibus bill because it would be considered controversial.
Oh.
Because we probably have someone
Somebody
opposing
who
it.
would, okay. So what would be the best approach to making this change to a statute?
Well, I think that just depends, if that's something that the profession wanted to pursue, then I think it would be up to the board to support it. If that's something the board wanted to pursue, then, we would have to find an author and go that route. Even work with DCA and maybe find someone.
So on behalf of HHP, I think at this point it would be difficult for us to proactively sponsor a bill on this, even though I think we all appreciate the issue and want consumers to know what they're up for when they make a purchase like this. We do have a number of members who, I hope that they wouldn't object to a disclosure, but it would take a longer assessment to figure out if we would want to sponsor a bill on it.
We wrote some facts for consumers. I think you wrote a whole document. Did we mention this for consumer be aware?
I think it is.
It's on the
It's
website.
on the,
Brochures
it's on
are
the.
right
It's actually in the back of
They're
the
right
room.
back there.
Yeah. Thanks, Vanessa.
Amy, did you have something to say?
Oh, just on CA's side, this has already been a discussion
Okay.
issue. The board's
Yeah,
voted.
let's see.
This would absolutely be something that we would support, even if we have to go on the legislative.
And in the back, there's a glossary in it.
Oh, yeah, this one.
I can tell you that HLAA would, I believe, reading their literature about it, that they would support it.
so hard for me to see an argument against it. It's so hard, just because, specifically just dealing with consumer protection and consumer awareness, it's just like pulling the wool over people's eyes. I feel so strongly about this. It's tens of thousands of dollars for a lot of people. It's a lot of money that they're spending on devices and potentially either moving or offices closing. It's so important, I feel. So whatever we find out we have to do, I think, is worthy.
Out of curiosity, what's been tried?
What's been tried?
What have you tried?
Oh, nothing other than coming and
Nothing
bringing it to
because
the
you
board.
can't.
Yeah.
Because we didn't go anywhere with it, we
And
just recognized it.
Yeah, we as NCAA and our business practices committee have come up with some statements, kind of a jumping off point of how we see, the informed consent statement looking and things like that, just so we were given.
What is it we're looking for? It's not in there.
We wanted to see if lock devices were covered in the
That's
consumer
another
hearing
addition
aid brochure.
in that
If
book.
lock devices were covered in the consumer hearing aid brochure.
It may not be.
Yeah.
but
Not in the
it
sections
should
that
be.
They're not
It should be.
specifically called out, and under the digital and programmable devices, I wonder if that's where it might
It
have.
should be,
Mhm.
yeah. Well, we knew that there were gonna be additions.
It's a living document.
Yes, that's a good way to put
Is it
it.
also available online?
It is.
Yes.
So we can change it online, but I
Yeah,
don't believe
he only got a
everybody
few of
print.
those.
Yeah, oh, yeah.
Few hundred of those. About 500. Okay, so,
Who should be?
That might be a section that could be adjusted.
I don't recall us, kind of developing a bill from within and seeing that process through, so I'm not sure exactly how it would work.
The board would vote to sponsor a bill. It would have to find an author, and then it would have to work with the author's office to.
Whose purview is it to find the author? A member of the board, a member of DCA?
You want to?
Well, do you want a legislative committee from our?
Okay,
That could
is
then
that
work
okay?
on legislation and.
If that's acceptable.
I think that would be a good task for that committee to pursue and to partner with the professional organizations and any other consumer organizations that would like to be part of that.
I think there's a number of authors out there.
Then
Okay,
we
so-
have people that will work on this and people who will make suggestions and recommendations and spearhead the committee from here, Paul, do you think?
Yes, I think you could, perhaps you can solicit from the board members, anyone who would like to be involved in that committee, and then you can select, or you can select who you would like to actually be part of that. Probably best to have just two people, so they
Yeah.
can,
I would say that this is a side conversation that should happen, but you have, within your chair delegation, the authority to establish committees and to put people on them. But because it's not really within this, particular agenda
Yeah,
item,
agenda.
the creation of a legislative committee, I would recommend to do that offline. Because
Okay.
you can do that at any time as the chair.
Okay.
Didn't we
All right.
do that, Paul?
not yet.
Not yet, okay. Okay, so, do we need a motion, or we're just going to acknowledge this discussion and offline?
I don't think it requires a motion, because Dee, within her chair authority, has the ability to create a committee and assign tasks to it, so
Okay.
unless the board would like to entertain a formal motion there.
No, I'm fine. All these
Okay.
numbers.
So, moving on to item number 8, I will be brief with my report. You have in front of you information and statistical reports behind the information. First off, I just want to talk about some of the personnel changes that have happened recently. As I announced to you earlier, Carla Newman, who was our special investigator, recently transferred to CAL FIRE for a promotional opportunity. Brianna and I have been recruiting for a new special investigator, and we are down to final candidates, and we'll be hopefully making our selection within the next week or two. And then there's, you know, background checks and other things that need to happen, so it does take some time. But in the meantime, we have had staff in the office that have been helping us fill this role. I've been working closely with both Katrina Martinez and Tim Yang, who have stepped up and really helped out a great deal. And our DAG liaison, Rose Luzon, has been great during this time. So we have tried to stay up to speed on all of our cases, our disciplinary cases, and our probationers. Excuse me. We also recently hired Heather Olivares, who you met yesterday, who joined us. She was previously our legislative analyst from DCA. So when she expressed interest in the position, it was, we saw it as a great fit, and she's been helping us. Just at this point, we're just kind of gathering all the workload, organizing it, and we have some big projects in regulations to tackle. And she will also be working with the newly formed legislative committee on some different ideas that she has for us that I think are going to be really, really productive and fruitful. We recently hired another enforcement analyst, young man by the name of Eli Heredia. I think I pronounced that correctly. I should know how to pronounce that. Who worked he worked in for the city and counties of Sacramento in code enforcement. He has some experience in investigations, and he's going to be helping us with consumer complaints and investigations.
Yay.
I'll go through the rest of the report, then we'll go to the individual report. Licensing cycle times. I just wanted to point out that, you know, I like to give you a snapshot of where we are at any given time. These are licensing cycle times for completed applications, and where we are with applications right now is we're about 3 weeks out. The last row in that column is hearing aid dispensers applications, and what we mean by current is those are actually processed in a matter of days. We did have a time, I think a year ago, where it was taking up to 3 weeks, but we've been able to stay current with those applications in the last year. I included the dates for the upcoming practical examinations. Just to keep you informed and up to date on a topic that came up yesterday with examinations. One of the reasons why it's difficult for us to conduct a practical exam in Southern California, we actually made an effort to do that. We contracted with San Diego, and there were some real difficulties in doing that, logistical difficulties. There's an increased cost to the board. The way our board structure is set up is we don't have special funding to conduct examinations. So I think in the coming years, we're going to try to seek budget authority to actually fund the examination program. And there's some different models that we're looking at that would be they would not be done in the manner in which we're doing them now. Right now we have an event where we invite people to Sacramento. We do them, 4 times a year, and it's limited because we rely on our examiners, we rely on staff, and they're done on the weekends. So we're looking at some different models that I think would make it a little more, try to improve consistency and availability. But in the meantime, we don't have that. So what we use the Department of Consumer Affairs facilities, and we conduct those on Saturdays. You have the dates here on the second page of the report. Any questions so far on any of the budget items or the report items? Okay. In enforcement, we currently have 16 formal discipline cases that are pending with the Attorney General's office. We monitor about 28 probationers. Of those 28, 8 require drug or alcohol testing, and 10 are in told status. And the last page of the report has all of the disciplinary actions that have been adopted by the board during the past 12 months. Behind tab 9B is the board's operating expenditure summary, and that gives you an idea of where we are in our spending. Right now we're projected at a surplus of 8%. The money that is in the surplus is carried over and goes into the board fund. Behind 9C, you have licensing statistical information, the number of licenses issued. If you're looking at this report, you'd want to look at the very last column, and that's the first quarter of what we have done so far as issuing licenses in the various categories. And then the second table shows you a snapshot of the current licensing populations for each category. Behind 9D are the results for the hearing aid dispensers practical exam that took place on July 21st. We're awaiting the statistics for the October exam, and we'll have those at the next board meeting. Any questions so far on the statistical information before I go to enforcement? The enforcement report, similar to what you're accustomed to seeing, I do want to point out that we will break down the speech and audiology statistics at the end of the fiscal year and provide a separate report.
Very nice.
To preempt the question that is coming. But in the meantime, you do see the first quarter statistics for the different categories of enforcement. Are there any questions on the report so far? I'm going to ask Heather to go forward and talk about legislation update.
Okay, good afternoon. If you will turn to tab 10, there's a memo in your packet, and then following that memo is copies of the final language for the bills the board was tracking, in case you want to read all of that. But I'll just quickly go over, the board was tracking 4 bills over this current year. 2 of the bills were signed and will become law, and 2 bills were vetoed. And all this happened by September 30th, which was the governor's deadline to act on all the bills that passed this year. So I won't spend much time on the bills that were vetoed, other than just to point out it was AB 11 regarding early periodic screening, diagnosis and treatment program. And that was vetoed because the governor felt that the Medi-Cal state plan already requires providers to screen children for developmental delays. And so codifying the requirement into law and requiring a reporting, the governor felt that was not necessary to do that. And then AB 1801 regarding newborns, and sorry, I can't pronounce this word, cytomegalovirus.
Good job.
Public education and testing. That was vetoed because researching, educating, and testing for diseases in newborns is actually a function of the Department of Public Health. So the governor felt creating a new body to do so was not necessary. So if you have any questions, I can go into further, but otherwise I wanted to more focus on what will become law and where we need to go from here. So AB 1659 is a pretty straightforward bill. It just gives all boards within the DCA umbrella authority to establish a lower renewal fee for an inactive license. So if the board has no desire to do so. This bill won't really impact us. It's more just authority to do so. Rather than going into every individual practice act, this bill just applies to all healing arts boards across the board. Is there any questions on that one? Seeing none. Okay, the big one that will be impacting us soon is AB 2138 regarding the denial of application, revocation, or suspension of licensure regarding criminal convictions. This board had taken an opposed position along with many other boards. Unfortunately, it will become law on July 1, 2020, and it restricts the discretion of boards within DCA from using prior criminal history as grounds for licensing determinations and establishes new prohibitions relating to the denial, suspension, and revocation of licensure. It prohibits boards from using acts involving dishonesty, fraud, or deceit that did not result in a conviction as a basis for denial, and establishes a 7-year limitation on convictions eligible for licensure denial, and bans requiring applicants to check a box basically on the form. And then there will be some data tracking and a publishing of data on the website and a legislative report that will be required as well. So Kelsey and I attended a meeting on Monday. There's a work group that's been formed with several boards within DCA, and we're looking at kind of where we combine sources, so to speak. Since this applies to a number of boards within DCA, we're all trying to kind of work together to streamline the regulatory process. And since the bill goes into effect July 1, 2020, we will need to have regulations in place by then. So we'll most likely be looking at some regulations at our next meeting.
Could I request and suggest that this issue be put on the legislative committee that's going to be formed?
Well, the legislation
Or
is
will this-
passed,
I
yeah,
know.
so legislatively, there's nothing we can really
Okay.
do about it.
You're
It's
right.
more like we're stuck with this and we have to implement it now.
So just out of curiosity, maybe you could just provide some background information about why our legislators felt that this was an important bill to be passed.
I can't really speak to their thinking, other than this year in general was a lot of reform on past criminal history. They reformed bail bonds. That was a huge issue that was discussed this year.
And part of this was the Little Hoover Commission. If you read the report, they were looking at barriers to licensure, and this was one of those areas that was identified.
Yeah, and there was a lot of overhaul just in general this year under this governor of his last year in reforming issues relating to past convictions. It's not because there was not a fight by any means. Almost all DCA boards took an opposed position, so you guys are not alone in disappointment in this bill passing, for sure.
So I do want to point out, though, that it is going to take significant work. This is a major change and departure from common practices, and it's going to include a lot of different regulation packages. And so because it is mandated, these regulations are probably going to take a priority. And so I just want to, I want the board to be aware of that, that these the board is going to need to redefine certain things in regulation because it's now not a substantial relationship test anymore. And so, and rehabilitation is going to have to be further defined within regulation. Your disciplinary guidelines might be affected. The good news about that is that there's still a work in progress, so.
They'll be on hold for a little while till we
yeah.
get to this.
Your applications are going to need to be updated. So it's going to take a lot of work. And so I will be working very closely with Heather to get that to you guys at the February board meeting. But that is it's a priority because in order to meet timelines for the implementation, boards need to have approved language around April of 2019. So my office and DCA is going to work very hard to make sure that these reg packages are all expedited and that we can meet these requirements.
Yeah, I have a question here. There's mentioned a 7-year limitation on convictions. I mean, if somebody has convicted for felony 8 years ago, doesn't count.
It does depend on the type of crime. So there are some carved out exceptions. Those include a serious felony as defined in 1192.7, so murder, for example, of the penal code, or a crime for which registration is required pursuant to the penal code. Again, so a sex offender, and so those types of convictions do not have an expiration date for that. They don't have a 7-year limitation.
But the financial fraud expires.
So financial, if the applicant was convicted of a financial crime currently classified as a felony that is directly and adversely related to the fiduciary qualifications, functions, or duties of the business or profession for which the application is made, pursuant to the regulations adopted by the board, and in which the applicant is seeking licensure under any of the following, and I'd have to look at that, but yeah, it's, so it carves out some exceptions, but it's not a sweeping.
And the other question that I have is bans requiring applicants to self-disclose prior conviction. So if the conviction was a year ago, a year before, it does not require, the applicant doesn't have to disclose it?
Right, the application itself cannot ask the question essentially. So right now you fingerprint all of your applicants, and so that fingerprinting should produce a hit, for lack of a better word, of any conviction. And you'd get a rap sheet, and that's how you would make your determination as to whether or not to deny the application.
On our renewal every year, we have to mark if we've been,
So
will you remove this question?
We're looking into whether or not the renewals are going to be affected by this, because this does speak just to an application for licensure. So, and previous versions of the bill did also include disciplining those that had a license. This is scaled back a lot. So my office is gonna do more research on it, but my immediate reaction is that the renewal may not be affected.
There's no fingerprinting with renewals.
Well, there is if you have not been fingerprinted.
So some may not have.
Isn't everybody going to be required to do new fingerprints?
So I believe you have a statute that allows if for example, someone was licensed long before they had live scan, in order to renew, they would have to do a fingerprinting. And all current applicants have to do a fingerprinting.
Question, because it's here we are in the mood of the season of this regulation. Can we ask citizenship proof? Or illegals can be now dispensers or something?
So that question isn't really pertinent to this particular thing. If you want to ask me that, we can talk about that offline.
Well,
it's just not really pertinent to 2138.
Any other questions on the legislation?
Oh, there'll be plenty.
Yes.
Yep. Yes. I will now move on to item number 11, and that is the board election of officers. Behind tab number 11 is a memo explaining the role of the board officers. In our case, we are required to elect a chair and a vice chair. We're asking that the board nominate and elect a chair and a vice chair to serve a one-year term beginning January 1, 2019. So I will entertain any nominations or discussion at this time.
Yeah. I would like to nominate Dee for the chair and Marcia as vice.
Can we do them together like that?
I second that.
Okay. Any discussion from the board? Do the nominees accept?
Yeah, that's a good question.
Let me ask that first.
Yes, thank you. Yes.
Okay. Now, any discussion from the board? They didn't know it was mandatory. Any discussion from members of the public? Okay, I'll just take your votes.
Yes.
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 No.
Yes. Are you
abstaining?
abstaining, Dee?
If I could say yes, I'll say yes.
You may vote for
Absolutely,
yourself.
thank you.
Yes.
Okay,
We thought we had to
It's unanimous. Wait. Thank you, Dee and Marcia.
Yes.
for-
Thank you. Thank you. There it is. We're back at the beginning on number 12, future agenda items and future board meeting dates.
Do we have agenda items?
I
Marcia,
do.
you had a
Yeah.
couple 800.
Will I put those in?
This is also a good time to propose any committee items that you might have. And of course, you could let me know later if you have any suggestions or proposals.
No, isn't there? Oh, one thing I can remember is we wanted to work on the number of clinical hours required of audiology, of AUDs licensees now, because it still says 350. It's the same as speech pathology masters. And we,
Increasing
no.
Increasing.
Yeah, because it's
okay.
now close to 1,800 or so, if not more.
Okay.
Um,
We have also listed the pending dates for our upcoming board meetings. I think we still have to secure a location for Los Angeles, but we're looking at February 7th and 8th and May 2nd and 3rd.
And then August and November again, you think probably? Like this year?
Oh, so I just remember, I found my paper with the other notes. If it doesn't say anything about the immediate supervision for audiology aids, and there's probably a number of other issues in there that we should probably tackle,
Okay.
because it's kind of, remember this?
Within the audiology aid topic?
Yes.
Okay. You can let me know specifically what those are other than supervision. Okay.
But there was this general feeling like it's just way too loose on what they can do.
Right, right, okay.
I'll look at it.
I don't think we've discussed that since Kelsey's been on lead council, so.
Nope. I can
It's another
confirm.
fun one.
Okay.
You thought hearing aid dispensers?
So we'll be looking at, do you think August and November
Yes.
for next year? Okay. Okay, got it.
So now we need a closed session.
And just say, let everybody know that you will only be reconvening an open session to adjourn. And that the webcast will not be running.
Okay. We want to let you know that we are now going into closed session, and when we reopen, it will only be to adjourn. So thank you for coming, and we'll see you next time.
And we're gonna let the webcaster back up too, before we do that, okay?